है केस? मार्च में तो आपको पिटीशन फाइल करके करना पड़ेगा ना, ऐसा थोड़ी होगा। पहले से फाइल होगा ना, पहले से होगा तो उस वक्त आप तो जब आपका एडमिट हुआ होगा तो उस वक्त तो नहीं किया। जब ऑलरेडी एक डेट फिक्स्ड है तो उसमें अलग से आपको पिटीशन फाइल करके आपको प्रीपोन करवाना पड़ेगा डेट, ऐसे नहीं होगा।
From supplementary list for mediation for mediation that cases, item 3, 2nd April 34 of 2007.
The state is on the other side. No. State is not on the other side. Other side is appearing.
Yes. Private person.
Sorry? Yes. Let the matter be placed before for the purposes of mediation. Before this matter is referred to Jalsa for mediation. कोई डेट कैसे फिक्स करें विदाउट द अदर साइड? नहीं कर सकते ना, आप अदर साइड को लेके आए, otherwise we cannot fix a date because there is a direction of the Supreme Court that a date has to be fixed for mediation while referring it to mediation. Next one.
Item 4, 2nd April 92 of 2007.
You come at 2:15. You come at 2:15 with Mr. Virendra Kumar. The parties are absent. The matter cannot be referred for mediation.
Item 5, 2nd April 132 of 2007.
Yes. There is the appeal and without appeal and we cannot refer the matter for mediation. उसमें एक डेट दे देंगे, इसको नहीं भेजे ना, कोई एक डेट दे देंगे उसको. Appellant is absent. The counsel for the respondent says that he has no instructions for referring the matter for mediation. Accordingly, this matter cannot be referred for mediation at this stage. Post on date बताइए. एक कोई डेट दे दीजिए. After होली कोई भी डेट, मार्च का हर एक केस में मार्च का डेट लेंगे. डेट क्या होगा? And appropriate है. listing ka date.
Item 6, second appeal 140 of 2007.
Yes.
Sir, I talked with she was available to send it to. It will be passed to her.
Okay, come and do 15.
Item 7, second appeal 149 of 2007.
Parties are absent. Therefore, this matter cannot be sent for mediation. Where is the other side? बिना consent के कैसे mediation में भेजेंगे? Instruction from whom? Instruction from client. Other side is not there. The proceeding is ex parte. Is anybody appearing? The proceeding is ex parte. Is appearing? Yes. Is it to be sent for mediation? With the consent of the parties, let this matter be referred for mediation before Jalsa. The parties are directed to appear before Jalsa. The parties कौन से दिन appear करेंगे बताइए? Which day? Sorry? 27th. होली के एक दिन पहले 25th को the parties undertake to appear before the Secretary Jalsa on 25th of February 2026 at 11 a.m. The Secretary Jalsa is at 1 p.m. The Secretary Jalsa is requested to appoint an appropriate mediator. The matter be placed before the bench immediately upon receipt of the mediation.
Item 8, second appeal 168 of 2007.
Counsel for the respondent submits that the party is not ready for mediation. कब करना है बताइए? करेंगे?
Your Lordship, 16th से जो week है उसमें लगेगा 16th March onwards.
Okay. With the consent of the learned counsel for the parties, the matter is directed to be posted for final disposal on 16th of March 26. The parties are directed to prepare short synopsis and also file the judgments necessary to read.
Item 9, second appeal 202 of 2007.
Yes, ma'am. Matter should be referred to mediation. Who's for the petitioner? In absence of the appellant, how do we refer the matter for mediation? Next week, sorry, I'm just posting it at 2:50. If they come, it's okay, we'll refer, otherwise we'll not.
Item 10, second appeal 312 of 2016.
That should not take it for immediate.
The counsel for the applicant has submitted that. Applicant is not ready for mediation. Specific performance.
No, sir. Substantial question.
Okay. Just a minute. Other side is active.
Not the applicant, नाम तो लिखा है एड्रेस बढ़िया होता है.
So respondent is active. Record आ गया? Record नहीं आया? It is already fixed for 26/3. Post this case on the prefix date, that is on 26/3/2026.
Item 11, second appeal 334 of 2016.
The counsel for the appellant submits that the matter may not be referred for mediation. Substantial question of law frame.
Already framed and running in the under the heading of finance. It was posted yesterday.
It is otherwise running
Yes.
on the phone. ठीक है रखिए. ये बेल लग गया है तो नहीं हो पा रहा है. थोड़े दिन की बात है.
10.
जो ऑलरेडी इसमें डेट कल आपने प्रोग्रेस में दिया हुआ ना डेट कल लगा हुआ था मैटर
कल लगा हुआ तो फाइनेंस डिस्पोजल.
अच्छा.
वो ऑटोमेटिक डेट पर
Paid cases from daily list for admission item 3, PA 10446 of 2025.
This is a case of a statute.
and hurt also. The lady was hurt also.
Yes, but their injury is simple in nature.
Injury is simple in nature.
Even the case, counter affidavit, error time.
You were apprehended on the spot.
No, sir. The allegation is that I was apprehended on the spot, but I was not arrested. Altaf Sheikh was arrested on the spot, and on his confession, my name is
So where do you say this?
from the case I wrote. Case 10. पुनर्व्याप में भी लिखा है. At para 4. From bottom full line. आगे बताया गया.
Just a moment. Para
4 of case 10. From bottom full line आगे बताया कि पकड़े गए लड़के का नाम अल्ताफ शेख, उम्र 19 वर्ष, पिता सचिन सच, उसके बाद इरफान शेख, और भागे गए लड़के का नाम इरफान शेख और मोहम्मद शेख.
अल्ताफ शेख 19 वर्ष पिता रशीद शेख
हाँ,
और भागे गए लड़का का नाम इरफान शेख पिता रशीद शेख.
पिता रशीद शेख.
बोथ आर ब्रदर्स.
बोलो.
पिता रशीद शेख.
जबकि सूची देखा जाए हम
नहीं बताइए दोनों भाई हैं क्या?
एक भाई नहीं है.
दोनों के पिता का नाम भी सेम है.
हाँ, पिता का नाम सेम है.
बहुत अच्छी.
और जबकि सूची में कलमुद्दीन अंसारी है पिता का नाम. जबकि सूची है एनेक्स पेज 15 ऑफ माय.
आपका क्या नाम है?
मेरा नाम इरफान शेख alias मोहम्मद इरफान अंसारी.
रशीद शेख का एक एलियस नाम भी है कलीमुद्दीन अंसारी,
Yes,
पिताजी का भी एलियस नाम है।
चार्जशीट जैसे एफआईआर में जैसे रहेगा उसको तो एलियस करना पड़ेगा। और चलती सूची में इरफान अंसारी, पिता कलीमुद्दीन अंसारी, फादर
कौन सा पैरा नंबर केस डायरी का?
किस है हम चलती सूची लगाए हुए हैं बच्चों इन द पिटीशन itself पेज 50
बताइए।
6 नंबर गिरफ्तार व्यक्ति का नाम पिता उम्र सईद, मोहम्मद इरफान अंसारी, उम्र करीब 19 वर्ष, पिता कलीमुद्दीन अंसारी, साकिन बरवाटार।
इरफान अंसारी, पिता कलीमुद्दीन अंसारी।
यस
आपकी का तो नाम है।
कलीमुद्दीन अंसारी है।
Since when are you in custody?
I am in custody since 22/8/2025.
And what is the date of incident?
Date of incident 22/8/2025.
तो
I was not arrested on the spot.
तो आप खुद ही बोल रहे हैं आप कस्टडी में हैं उस समय से।
हाँ, अल्ताफ शेख अरेस्ट हुआ और अल्ताफ शेख के डिस्क्लोजर में मेरा नाम आया। अल्ताफ शेख के उसके बाद उनका फोटो से नाम अरेस्ट हुआ। एफआईआर टाइम ऑफ एफआईआर इज 2:10 टाइम ऑफ ऑकरेंस, एफआईआर इज 3:30 and I was arrested on in that day itself at 9:10 p.m. as per the arrest date. It is for 10 days.
आपका अरेस्ट कितने बजे है?
21:10।
उनका अरेस्ट है 17:30।
21:10 हाँ 7:30 अल्ताफ है।
जबकि सूची में 17:40 है उसका अल्ताफ शेख का।
So Altaf Sheikh has been arrested first person. He was apprehended on the spot. His confession is in para 7 of the case.
Have you been identified?
No, no.
आपका टीआईपी में कुछ नहीं?
Identified नहीं है।
Yes, you have filed your contract with it. बताइए, क्या है? He says that he was arrested later on. How do you explain it in the contract? Which paragraph are you referring to?
पहले जो पकड़े एफआईआर में तो यही करा, लेकिन बाद में ये वो जो उनके कन्फेशन पे जिसको पकड़ा गया वो अल्ताफ शेख थे जो पकड़े गए थे, और जो बाद में पकड़े गए वो इनकार थे।
तो ये तो इरफान शेख का है, petitioner है, he was arrested later on. इनके पास से कोई रिकवरी है? चार्जशीट हो गया? BA number 10446 of 25. Counsel for the petitioner submits that the matter relates to snatching of chain and injury suffered by the victim in the process. He submits that the petitioner was not apprehended on the spot. Rather, he was arrested on the confession statement of co-accused Altaf Sheikh, who was apprehended on the spot. There is no recovery from the petitioner. Charge sheet has been submitted and the petitioner is in custody since 23/8/2025. 22/8,
next year.
23/8/25. Counsel for the state has opposed the prayer by referring to the counter affidavit. However, from the materials on record, the counsel could not the fact that the petitioner was arrested later on is not in dispute. Considering the aforesaid facts and circumstances, and that the name of the petitioner has come in the confession statement of the co-accused, and there is no recovery from the petitioner is likely to be enlarged on bail. बाकी यूजुअल कंडीशन अपना पैरवी का रेट जो भी है ना
हाँ,
आपका
पिताजी
जो भी है should be one of them.
Item 4, BA 10450 of 2025.
But paying for past.
Second half, 215.
Item 5, BA 10457 of 2025.
The number 10457 of 25, counsel for the petitioner seeks permission to withdraw this petition. Accordingly, this petition will be withdrawn.
Item 6, BA 10467 of 2025.
The son of the informant was killed. First information report was lodged against unknown. Subsequently, one of the co-accused persons he was arrested, Roman Ram, and on his confessional statement, the name of the present petitioner transpired, and thereafter she was taken into custody, where it is alleged that she also gave a confessional statement about the murder. The only allegation that has been leveled in the statement of Roman Ram and the rest of the accused, Prakash Singh, that it was this petitioner lady who had given rupees 2 lakhs for commission of the murder.
She had hired them.
That is the confessional statement. They can accept the confessional statement. There is nothing on record, even in the case diary, to show her implication, nor any incriminating article, nor anything has been recovered. Save and accept the confessional statement of the co-accused, coupled with the confessional statement made by the lady, there is no other allegation as against her. And she is already in jail custody since 30. She voluntarily surrendered, which we have stated as paragraph 6 on 19/5/2025.
Charge sheet submitted.
That's it.
What is the stage of crime?
Charges are. Charges are.
Yes. Who are you? You're for the state. What is there apart from the confession statement?
Petitioner given summary to the Roman Ram
ठीक है, वो तो allegation है.
for committing murder. Due to we are disputing
That's-
पर भैंसुर करते थे अपना ही.
That's
इनका ये सस्पिशन था कि इनका जो हस्बैंड को ये हुआ था वो एजेंट से मर्डर हुआ था, तो हुआ था. इनका ये था साख था कि वो एजेंट के मांगे.
इनके पास मटेरियल क्या है इनके अगेंस्ट? कन्फेशन के अलावा
इसके अलावा तो इनके पास कुछ नहीं, बाकी जो ये है
PA number 10467 of 25. Counsel for the petitioner submits that the FIR is against unknown. Named नहीं है ना FIR?
No, no.
And on the basis of mobile location, one Doman Ram was arrested, who has taken the name of the petitioner in his confession statement and has also named other accused persons. He has alleged that the petitioner had hired criminals to get the deceased murdered. The deceased he has further submitted that there is no recovery and the petitioner is in custody. There is no recovery from the petitioner and she is in custody since 19/5/2025. The charge sheet has been submitted. The charge has already been framed. It's a correct information, na?
Yes, yes.
The charge has already been framed. The learned counsel for the respondent has not been able to point out any further material from the case diary with regard to the involvement of the petitioner, but has submitted that there are enough circumstantial evidence to show that the petitioner was involved in the case of engaging criminals for the murder. After hearing the counsel for the parties and considering the facts and circumstances of this case, that except confession statement, nothing material could be pointed out from the records. The petitioner is directed to be enlarged on bail.
Item 7 PA 10537 of 2025.
Yes. You are named in the FIR. Wife of Ghulam Maria, एक ही wife है ना? Your identity is not in this. ये dying वाला case है वो. Not a case for bail.
they come near the house of the informant.
वो पूरा कहानी लिख.
कहानी के इसमें सिर्फ हमको ये बोलना है कि petitioner है having a 6 years child and
कोई बात.
this is general and omnibus
Allegation general and omnibus.
Omnibus.
आपके ऊपर specific है.
नहीं स्पेसिफिक मेरे पर
नहीं, एकदम
क्योंकि I am the family member of तीनों मरिया.
Not the family member. There is much more. There is much more.
मतलब कुछ इसका कोई ओवरटैक वगैरह कुछ नहीं. लेडीज है ये बरसी में उनको
लेडीज को सोचना चाहिए डाइन वाला काम नहीं करना चाहिए.
ये दान वाला नहीं बोले इसकी जो तीनों मरिया गुलाब मरिया
डाइन तो लेडीज ही होती है. कोई आदमी लोग डाइन होते हैं क्या?
कोई टाइम नहीं डाइन तो कोई होता ही नहीं है.
मतलब सोसाइटी में. Not a case for me.
और एक इम्पोर्टेंट पॉइंट है जिसके बारे में डाइन बोला जा रहा है. चरकू है चरकू चुटकी रानी. She has not been examined by the IO, which indicate that entire case is concocted and make out a case of Dine and Dine Act. जिसके बारे में Dine बोला जा रहा है उसका एग्जामिनेशन ही नहीं.
बहुत अच्छा.
इसीलिए डायरी कॉल और ये सी इज इन कस्टडी सिंस 6/3/2025.
इलेक्ट्रिक पोल में बांध के मारे हैं, मतलब कोई लिमिट है?
मर भी गए
हम मर गए।
मर भी गया, एक को इंजुर्ड भी है, दैट माइट स्टे इन द इंजरी रिपोर्ट आल्सो.
कस्टडी कब से है?
6/3/2025. Ladies are having a child.
लेडी के लिए कोई स्पेशल लॉ नहीं बना।
लेडी है, कोई भी जब मेल मेंबर सब लोग है तो ये लेडीज जाके स्पेशली मार,
लेडी लोग ज्यादा इन्वॉल्व होती है सब चीजें, ये भी सोशल फैक्ट है।
लेकिन बांधने और मारने में तो लेडीज नहीं.
ऐसा तो आप गलत सोच रहे हैं।
वो भी पुरुष को
कोई बात नहीं, नॉट अ केस फॉर मी।
some observation.
क्या ऑब्जर्वेशन चाहिए? ट्रायल का क्या स्टेज?
ये इंटू ऑर्डर में आया है, इस केस इज अंडर एविडेंस.
एविडेंस कितना विटनेस एग्जामिन हो चुका है?
वो वही नहीं.
कोई आपको नहीं पता तो क्या ऑब्जर्वेशन है?
इसमें हाँ आज ही बात हाँ 11 में 3 ठो का एग्जाम हुआ है.
स्टेट तो सारा विटनेस प्रोड्यूस करेंगे ना आप प्रॉम्प्टली।
But I have yes, cutting but case study just now we have received a case study.
अरे मेल नहीं दे रहे हैं आप, विटनेस प्रोड्यूस करेंगे ना?
जी सर, जी.
बस इनका अंडरटेकिंग और क्या चाहिए आपका? एक्सपीडिशियस ट्रायल अपने हो जाएगा।
सब ऑब्जर्वेशन
को वही ऑब्जर्वेशन बीए नंबर 10537 of 2025. The learned counsel for the petitioner has submitted that though the petitioner is named in the FIR being the wife of Gula Maria, but there is no specific against the petitioner. There is no specific allegation against the petitioner. He submits that the petitioner being in custody since 6/3/2025
mother of 6 years
and a mother of 6-year-old child, she may be released on bail. The learned counsel for the opposite party has opposed the prayer and has submitted that the charges against the petitioner are very serious in nature and there is direct allegation against the petitioner who was involved in the commission, who was directly involved in the commission of offence. She has also stated that the trial has commenced and the state shall produce the witnesses promptly before the court. Considering the submissions and the serious nature of allegation against the petitioner, who is not only named in the FIR, but the manner in which the incident has taken place, this court is not inclined to enlarge the petitioner on bail. The counsel for the state is directed to the state is directed to ensure prompt production of witnesses in the court as has already been submitted by the learned counsel appearing on behalf of the state. Counsel for the state is directed to communicate this order to the concerned authority to ensure compliance. Okay, बस
some time frame में
नहीं दे सकते हैं ना? नहीं दे सकते. Not possible.
Item 8, BA 10562 of 2025.
Charged under section 103 of BNS, the application is not of committing murder of the minor's informant's mother. The last date minor's ID was called for, because the trial has already commenced, and because the 2 witnesses have been examined as per the case status minors, and the custody is since 30th September 2024.
How many witnesses are left?
Because there are 6 charge sheet witnesses.
Only 4 witnesses are
4
left.
to be left.
At least two of them must be official witness.
That
Must
information I
be.
couldn't get.
पोस्टमार्टम रिपोर्ट का एक डॉक्टर होगा, एक आईओ
हाँ,
होगा.
वो तो है. अभी
ये तो है ही.
एग्जामिनेशन किसका हुआ है ये नहीं पता है मेरे
पहले पोस्टमार्टम रिपोर्ट थोड़ी एग्जाम में होता
को.
है.
जी. और लास्ट डेट पे विटनेस नहीं आए थे. दिस वाज द केस स्टेटस फ्रॉम द वेबसाइट आई कुड.
आप प्रोड्यूस करेंगे ना विटनेस? ये तो करेंगे. What a case got made. आपके यहाँ से रिकवरी है.
चीनिंग क्या रेट थी सेवा विटनेस में
कोई बात नहीं. आपके यहाँ से रिकवरी है ना डेड बॉडी की?
नहीं
मटेरियल्स उसका
इंप्यून ऑर्डर में ये आया है कि ना इंक्वेस्ट बना है ना मेरे पास से कोई रिकवरी है. दैट इज द रीजन नॉट.
नहीं आपके यहाँ से चूड़ी वूड़ी क्या क्या चीज रिकवर हुआ है? ऐसा नहीं है आपके यहाँ से कोई रिकवरी नहीं. And you had taken her.
That is the allegation. I go down but I will not make any submission which is contrary to the words.
Body has been recovered.
Body has been recovered. Impugned order में जो मेरा सबमिशन आया है यही आया है कि मेरे पास से कोई रिकवरी नहीं है.
ठीक. BA number 10562 of 2025. The learned counsel for the parties have present. Counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and the allegation is that the petitioner had taken the informant's mother for working in Ita Bhatta, and ultimately she was assaulted and killed. He submits that there is no eyewitness to the occurrence, and the petitioner is in custody since 2024. The trial has commenced, and out of 6 witnesses, 2 have already been examined. And he also submits that on the last occasion, the witness was not produced by the prosecution. The learned counsel for the opposite party state has opposed the prayer and has submitted that some articles were also recovered from the possession of the petitioner in his house. है ना? Yes or no? है कि
रिकवरी के बाद इसमें कुछ दिया नहीं डायरी में किसी
रिकवरी का मेरा
ये
केस
डायरी
वही था ट्रायल कोर्ट में. मेरे पास कुछ रिकवर नहीं हुआ.
जब्ती सूची घटना स्थल पर बरामद.
हां
एक मरून रंग का टूटा हुआ चूड़ी तथा हरा रंग का टूटा हुआ कलेज, लाल रंग का खून लगा हुआ साड़ी एवं
यस पाराफॉर्म है पाराफॉर्म यस पाराफॉर्म
Yes, therefore
खून लगा उधर से तैयार किया गया.
Yes, therefore to paragraph 4 of the case diary. He has submitted that since the trial has commenced, the prosecution shall ensure prompt production of witnesses. Considering the nature of allegations and the materials collected during investigation, this court is not inclined to grant bail to the petitioner. However, the learned counsel for the state has already submitted that the state would ensure prompt production of witnesses. The counsel for the state is directed to forward a copy of this order to the concerned authority to ensure prompt production of witnesses. Communicate.
Item 9, BA 105.70.2025.
Petitioner. Who is for the petitioner? कौन है? पास ओवर कर दे रहे हैं सारे मैटर्स. जो नहीं आएंगे उनका केस हम डिसमिस भी करते हैं. dismiss for non-prosecution.
Item 10, VA 10607 of 2025.
Earlier withdrawn my lord from coordinate bench.
It has to go.
No, that bench is not available.
What do you mean not available?
Honorable says Ambuj.
अच्छा एक केस में मिस्टर राजेश कुमार के यहाँ से जस्टिस राजेश कुमार के यहाँ से विड्रॉ हुआ था मैटर.
If it is simplicity, as per my simplicity of withdrawal, without going to the
It is a tied up matter because that amounts to bench hunting.
But this bench is not available, madam.
I know, but that amounts to bench hunting.
No,
So
obviously.
simplicity of withdrawal is I have consulted other judges also in the
There are
morning.
several other judges who are hearing those matters.
No. So therefore, I could drag up somebody to find out, and then I am told that it is a tied up matter. एक केस में जस्टिस राजेश कुमार का था, वो उनसे मिस हो गया कि क्या हो गया पता नहीं.
Somebody has not pointed out in the council. This is the bench is not available.
हमको याद नहीं है कि कौन सा केस में था. I don't remember. हाँ बताइए.
My lord, it's a cyber crime case, my lord. Recovery of 5 mobiles and 7 SIMs. Custody from 3/4/2025.
Where is the respondent?
Huh?
Counsel is not here. मोबाइल तो एक भी आपके नाम का नहीं है.
नहीं, मेरा नाम नहीं.
ठीक है ना, आपका नाम का नहीं है.
नहीं.
अब क्या बेल देंगे आपको बताइए.
The accused has been granted bail, but on a duty by depositing the money. Should I show that?
नहीं ऐसा
नहीं.
मनी डिपॉजिट
No,
वाला
no,
ऑर्डर
no.
नहीं है.
My duty is to first tell the
ठीक. मनी डिपॉजिट वाला.
But I'm not saying that. My only thing is this: 9 months. That it was withdrawn only for the reason because you think that 9 months.
Reason is not apparent from the order of withdrawal.
Pardon me?
Reason is not apparent.
Yes, that is there. That is there. Well, but I am only on this matter. He is in custody from 3/4/2025, and not in the mobile is not in my name. Mother is 467, 468 edition. Then at least the false document I have not created because it has been created by then the Vodafone or the service provider. They should also be made as an accused. Just my submission. I am only on this. This charge has been framed on 8/9/2025. Thereafter, 9 dates are gone. Till date, not even a single witness has been examined.
How many? Okay. Charge has been framed on this, and thereafter the witness has not been.
Not every time.
When did the trial commence?
Charge has been framed on
Frame होने के बाद तुरंत ही commence हो जाता है क्या trial?
Then 437 there is a clause, man. On the first day of the within 60 days it is not completed. Then there is a discretion of the magistrate to grant bail, man. मतलब charge sheet witness complete.
नहीं आपका सारा witness का appearance हम ensure करते हैं. That I will ensure that all the witnesses they come and depose.
But there is no victim in this case.
Need not.
Lord, the only connecting factor is that, my lord, there is a provision under. Can I argue, my lord, one point of law? There is a under the IT Act. There is a provision, section 81 of the IT Act, my lord, which has an overriding effect over all general laws, my lord. And 419, 420, and 66B and C are parametric to each other, my lord. Only the computer device is the thing. Use of a computer device and
Quashing बहस करिए.
no. हमसे बहुत टाइम हो गया कि एक साल
बेल में हमको इतना नहीं.
एक साल हम बेल में करना भी नहीं चाहिए. सब करना भी नहीं चाहिए.
हम यहाँ पे pronounce कर देंगे आपके submission पे तो आपको दिक्कत हो जाएगी.
3/4/2025 only on this, my lord, that no criminal antecedent and the witness has not been examined. The PP I've seen the autopsies also. Every time PP is called upon to produce they are not produced.
नहीं एकदम produce करेंगे उसमें.
Some observation and
I will give you observation that they have to produce the witnesses strongly. ये जो साइबर क्राइम है ना, सोसाइटी का नया दीमक है, नया दीमक है सोसाइटी का, न्यू टर्माइट.
But
I know,
there are several
but only if
pros and
there
cons
are,
also, madam.
yes,
There are
there are
several
several pros and cons.
Several pros
Material
and
होगा
cons.
तो रिकॉर्ड पर के ही बेसिस पे ऑर्डर होगा,
Now-
उसके बियॉन्ड नहीं होगा. Merely because somebody is involved in cyber crime ऐसा नहीं है कि उसको हम बेल. कल हम दिए भी हैं और हम
हाँ,
ऐसा
दिया।
नहीं है, हम नहीं सोचते कि नहीं देंगे. मटीरियल होने पे थोड़ा मुश्किल है.
Material इसमें सिर्फ वही सिम वाला बात.
यस, सिम वाला बहुत सीरियस बात.
मेरा सा भी है कि फॉल्स डॉक्यूमेंट हम क्या क्रिएट किए.
That's
That is a senior one on for 467 416.
That's it. देखिए. For the learned counsel appearing on behalf of the petitioner, the counsel submits that the petitioner is in custody since 3/4/2025 and except that he was caught hold with numerous
5 mobile
services. There is
mobile
no
sets
5 mobile sets
and
there
7
is-
SIMs.
and 7 SIMs. There is no material against the petitioner. The charge sheet has been the charge has been framed on 8/9/2025, but till date no witness has been examined. After hearing the learned counsel for the petitioner and going through the case diary, this court finds that the material on case diary reveals that he was found with the mobile number, mobiles and the SIM numbers which were standing in name of other persons. And it has been alleged that these instruments were used for the purposes of committing cybercrime. The details of the mobile and the SIM numbers have already been provided in the case diary. And upon further verification, the address of these persons could not be located. In whose name the mobile, many of the persons in whose name the mobile and the SIM were issued, and it is alleged that the petitioner has obtained mobile and that should be sufficient. Considering the nature of allegation and that the trial has already commenced, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses on the date fixed by the learned court.
17/2/2000. Today is the date.
Respondent है नहीं. Let this order be communicated to किसको? To the superintendent of police. कहाँ जाएगा?
Jharkhand.
To the superintendent of police Jamtara to ensure that the witnesses are promptly produced in the trial.
If some observation, but if the trial is not concluded with, because it is a magistrate tribunal
वो आगे.
case.
आप ही को खोज रहे हैं हम. इनका अपीयरेंस रिकॉर्ड करने एक लाइन लिख लीजिए. Here the board of prayer for them. Witness से प्रोड्यूस कर रहे हैं. बेल तो हम रिजेक्ट कर दिए हैं. Witness से प्रोड्यूस कर रहे हैं is very serious. ठीक है? Counsel for the state is directed to communicate this order before the competent authority to ensure prompt production of witnesses on various dates as may be prescribed.
If not, some observation, my lord.
ये नहीं कंप्लाई करें तब बताइएगा.
At least a time frame, my lord, because all magistrate tribunal cases there is.
नहीं, ऐसा कोई टाइम फ्रेम नहीं दे सकते. कोर्ट पे बहुत प्रेशर रहता है.
Court is trying their level, but every day 15 days they are giving time. The prosecution is not producing it.
They will produce it. Produce करेंगे ना आप? Commitment.
Item 11 PA 10608 of 2025 along with item 12 and 13.
Case is assigned by Lordship. In the instant case, Lordship, it is alleged by the prosecution that on the basis of information, if 4 persons were apprehended from whom mobile phone, ATM cards, etc. are recovered, and it is alleged that
कौन सा पहले करें?
चंद्रमोहन
चंद्रमोहन। इनके पास से भी रिकवरी है?
2 मोबाइल का रिकवरी है सर। कोई
कितना सिम?
जो मोबाइल में सिम लगा हुआ है बस वही है और
मोबाइल और सिम किसके नाम से है?
SIM is alleged in prosecution कि SIM has been issued in the name of other persons. सब चारों का जो है और इसमें 4 लोग पकड़ाए थे, 3 लोग बिफोर लॉर्डशिप, एक दिन का बेल हो गया लॉर्डशिप। इस केस को जो सिलेक्ट करते अगेन and in course of investigation lordship
विक्टिम नहीं आया तो क्या हुआ? मोबाइल तो आपके नाम से नहीं है ना?
खगेन का बेल हो गया।
अरे भाई विक्टिम नहीं आया, विक्टिम यानी कि जिसका
आया है ये खगेन के खिलाफ में नहीं, एक है असलम, he has been charge sheeted witness lordship, charge sheet submit हो गया है, that is
सेम ऑर्डर कर दिया रवि की फ्रॉम प्रोडक्शन ऑफ विटनेसेस का ऑर्डर कर।
इसका कोई ये नहीं, जैसे चंद्रमोहन का देखिए, चंद्रमोहन एंड कैलाश और फुल ब्रदर्स, पुलिस जो सब को इम्प्लीकेट करे सब नहीं, और कोई एंटीसीडेंट
आपके पास से रिकवरी है ना?
2 मोबाइल का दिखाया गया है कि हाँ 2 मोबाइल का रिकवरी है मेरे पास से, लेकिन उसके रिलेटेड में कोई विक्टिम जो है
विक्टिम मतलब 2 तरह का विक्टिम, एक हुआ कि उस फोन से यूज करके कुछ पैसा इधर उधर ट्रांजैक्शन, दूसरा हुआ है कि आप दूसरे का फोन आपके पास है। Why will you carry a phone which is standing in the name of somebody else?
उनको चार्ज शीटेड विटनेस ही बनाया गया है कि हम उनका फोन लिए हैं या उनका इनके नाम से
आपके पास से रिकवरी है तो उनको प्रूफ करने का क्या जरूरत है? आपको ना प्रूफ करना पड़ेगा डॉक्यूमेंट के साथ दैट इट इज योर मोबाइल। क्या आईपीसी खुले नहीं है, थोड़ा थोड़ा याद है हमको।
नहीं, इनको अगर कहना है कि हम किसी का सिम ले लिया
नहीं देखिए, आई टेल यू वन थिंग, आई विल अडॉप्ट एकदम एक स्टैंडर्ड। अभी हम एक बेल रिजेक्ट किए इसी ग्राउंड पर, मोबाइल एंड सिम दूसरे के नाम से है, हम बेल लेंगे, दैट इज एब्सोल्युटली माय डिस्क्रिप्शन। और दूसरे के नाम से है, आई विल नॉट गिव यू बेल।
इस केस में जो खगेन जी का बेल हुआ है कोई का उससे प्रायोरिटी पे है लॉर्डशिप इनका केस।
प्रायोरिटी पे नहीं है, क्योंकि हम ऐसा समझते हैं कि अगर दूसरे का मोबाइल आपके पास से रिकवरी है, ठीक है, तो देयर इज अ विक्टिम unless it is for you to prove your documents that
के केस में
it is not your case that the mobile and the SIM belongs to you. Is it your case? It is not your case.
खगेन के में भी जो सेफ पोजीशन था इन्वेस्टिगेशन
कोई बात नहीं, I will distinguish it. Don't worry.
चार्ज शीट भी आ गया
I
है,
will distinguish it. Don't worry about it. वो सब हमको आता है।
आप तो इसमें इसलिए कंसीडर था, स्कोप था स्पेस फॉर कंसीडरेशन कि कोई एंटीसीडेंट इनका नहीं है, अगस्त से जेल में है, पहले कभी किसी
कब से जेल में है ये बताइए?
26/8/25
और चार्जशीट हो गया,
चार्जशीट है ऑलरेडी सबमिटेड,
ट्रायल कमेंस हो गया,
पुलिस पेपर के सप्लाई पे चार्जशीट नवंबर में 19/11/2025 को सबमिट हो गया है। और इवन कैलाश में जिसमें कहते हैं कि एक विक्टिम है कि असलम का कि 52,000 रुपया ये होगा मनी ट्रेल हुआ, वो किस अकाउंट में गया है उसका ये नहीं करे कि हाँ इस नंबर से फोन आया था जो नंबर कैलाश के पास से रिकवर हुआ है। और राहुल
अभी ये तो सबसे पहले ये चंद्रमोहन के मंडल के खिलाफ 2 मोबाइल and 2 SIMs, 2 mobile and 2 SIMs standing in the name of different persons, and you have no documents in support of that, correct? आप बताइए क्या बोलना है इस पॉइंट?
लॉजिक पार्ट 72 and 75 दो कंप्लेन ऑफ साइबर फ्रॉड इनके अगेंस्ट में नोटिस नहीं किया 12/72 and 70. चार्जशीट की कॉपी है 10 चार्जशीटेड विटनेस है उसमें जो विक्टिम से सीरियल 9 में एमडी असलम को he has been made a charge sheet and the statement of the victim has been recorded.
उतना नहीं हम देख सकते। आपके पास डॉक्यूमेंट है, आप अपना देखिए। BA number 10615 of 2025 for the learning council appearing on behalf of the petitioner. He has submitted that except recovery of 2 mobile and 2 SIM in the said mobile, there is no material against the petitioner to connect him with the commission of cyber offence, and no victim has been found. The learned counsel for the opposite party has
Antecedent.
He has also submitted that the petition has no criminal antecedent. He is in custody since 26/8/25. The charge sheet has been submitted on 19/11/2025, but the charge has not been framed so far. There are altogether 10 charge sheets.
Yes.
The learned counsel for the state has opposed the prayer and has submitted that the mobile phones as well as the SIM are standing in name of different persons, and the petitioner was not found. The petitioner is not in a position to explain his possession of the mobile and the SIM. He has further referred to paragraph 72 and 73 of the case diary and has submitted
72 and 75.
72 and 75 of the case diary to submit that the complaint with regard to commission of cyber fraud has been found in the portal. Yeah. Which connects the petitioner from the crime. After hearing at this, the learned counsel for the petitioner has submitted that one co-accused, namely Khabin Dan, has been granted bail by coordinate bench of this court on 8/12/2025 in DA number 10027 of 2025. After hearing the learned counsel for the parties and considering the fact that mobile phones and SIMs were recovered from the petitioner which stands in the name of other persons to which the petitioner has no explanation, and by referring to the case diary, the counsel for the state has pointed out the offence that has come in investigation that cyber offence was committed by using these mobile SIMs and by using these mobiles and the SIM. So far as the grant of bail to other co-accused is concerned, it appears that the facts of the present case are different. And there is enough material against the petitioner to in the present case there is enough material against the petitioner. In view of the aforesaid facts and circumstances, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses during the trial. Counsel for the state is directed to communicate this order to the concerned authority to ensure this. बाकी सब सेम है, सेम स्टोरी। पैराग्राफ बताइए।
नहीं दूसरे कैलाश सर
बताइए।
कैलाश वाले में विक्टिम है 85 विक्टिम्स है और इनके पास सिर्फ 3 मोबाइल फोन है
कैलाश, इसका 3 मोबाइल, how many sims?
ATM cards और एक chip and a cash of rupees 1,11,000.
ATM card, cash, etc. has
Cash
been
of rupees 1,11,000.
1,11,000 has been
And
recovered.
one criminal antecedent of 2018, that is 7 years back.
इसमें तो कोई भी उसका बेल का कहानी बोलना है क्या? बोलना है तो कोई बात नहीं। लेकिन BA नंबर उसको वो भी इसी से रिलेटेड है ना?
हाँ, same case.
BA number 10608/25. The learned counsel for the petitioner submits that the petitioner is in custody since 26/8/25. The charge sheet has been submitted on 19/11/2025. He has submitted that there is recovery of 3 mobile ATM card, 1 ATM card,
Only 3 mobile apps.
3 mobile and
Several sims. 4 ATM cards.
3 mobile, several SIMs and
ATM cards.
/ATM cards.
In name of cards.
In the-
Wife का है उसमें
Just a moment. Please hold on, आपस में मत लड़िए. And also cash of rupees 1,11,000. And he has one criminal antecedent of the year 2018,
Yes.
which he is still facing trial.
Yes.
In which he is still facing the trial. The learned counsel submits that otherwise the petitioner is innocent so far as the present case is concerned. And he has been falsely implicated in the present case. He has referred to the grant of bail to the co-accused. वो जो दिया है ना डिटेल, the learned counsel for the opposite party has opposed the prayer and has submitted that most of the mobile and the SIM and the ATM cards which have been recovered from the petitioner neither belongs to the petitioner nor to his family members. And
ATM family member.
ATM सब family member का है।
कैलाश मंडल का भी कह रहे हैं अपने FIR में जबकि खुद लिखते हैं कि देखिए जब पेज 18 में एक ATM कार्ड चंद्रावती देवी वाइफ का है कैलाश मंडल के नाम से है ATM कैलाश मंडल के नाम से है ATM फैमिली मेंबर
Okay, most of the
सिम्स
SIMs do not belong to the petitioner or his family member. How many SIMs have been recovered?
चार सिम्स
How many? 4 SIMs. And चारों इनके नाम से नहीं है.
सिर्फ एक के बारे में लाए हैं कि वो जो है देवेंद्र मांझी के नाम से 2 सिम इनके नाम से बाकी 2
2 of the SIMs is in the name of the petitioner and the 2 SIM belong to third parties, to which the petitioner was not able to account for. He has referred to paragraph number 73 and 74,
23, 74, 76 and 77.
76 and 77 to submit that the mobile and SIM recovered from the possession of the petitioner has been used for commission of cyber offence and the various persons have been defrauded. बाकी सेम ऑर्डर. और बताइए तीसरा कैलाश मंडल हो गया. हाँ, रोहित कुमार मंडल. इनके पास से क्या है?
Two mobile phones, 3 SIMs, and ATM cards which belong to the present petitioner. These are
3
listed.
SIM or mobile and 8 SIM all belong to the
SIM,
present.
my lord, I may say one thing. One SIM was inside the mobile cover, and that SIM has been said to be forged, but belongs to some other person. That was never used for anything. Coupled with the fact, my lord, the person who has been granted bail, similar thing facts were there. There also seems to have belonged to some other person.
I do not know, the order is not effective.
That
You
can
see,
be,
therefore,
that can be seen from the
no, we will not see it like that.
from
You see, the consideration which has gone through the mind of the court, I'll see that. I'll only see that.
yesterday Lordship has considered one
No,
parity
I have
matter.
considered it.
The parity
The
on the
parity I'll see, but the provided the consideration is also on the same level and the same parity.
I was
We do not.
meticulously hearing this, that in a cybercrime case only the lady was granted bail.
I will grant bail. It's not that I will not. You see, I
But
have
here the thing is that now the
two mobiles, three mobiles,
two mobiles, three SIMs.
three mobiles,
And 4 SIMs.
four SIMs. All the mobile belong to you.
Two SIMs are belongs to him and
Two belongs to him.
two in
Two in name of third party. And three mobiles में से तीनों मोबाइल इनके नाम से.
मोबाइल का नहीं है EMI तो
नहीं वेरिफिकेशन नहीं है कहीं तो कुछ नहीं है.
मोबाइल सेट के बारे में नहीं है मोबाइल सिम्स के बारे में.
अच्छा ठीक है. चार में से दो ही इनके नाम से.
But एक ही सिर्फ जो SIM that was kept inside the 79 three SIMs sir. For my three SIMs.
क्या नाम है आपका? रोहित कुमार मंडल.
तीन SIM. हम ठीक से देख के बोल रहे हैं. तीन SIM है.
आपका जो लिस्ट है ना, लिस्ट ऑफ
Season
साइबर
list.
क्राइम which has been committed
Season
and the amount.
चार SIM है लोग.
Sorry.
सीजन इस सीजन इस देख लिया जरूर.
हाँ बताइए. आप लगाए हैं सीजन लिस्ट?
हाँ. एकदम part of the FIR. चार है. चार.
चार सिम है.
हाँ चार
चार
SIM.
में दो दूसरे के नाम से दो के नाम से.
एक SIM बोल रहा है. एक बोल रहा है. बबलू रॉय के नाम से एक SIM.
कौन सा पेज नंबर पढ़ रहे हैं? सीजन लिस्ट कहाँ लगा? पेज नंबर बताइए. 17.
Last details of the item seized.
Yes.
रोहित मंडल उम्र 25 वर्ष पिता सचिन से डायना पॉकेट से वीवो मोबाइल से जिसका IMEI नंबर सचिन से जिसमें एयरटेल मोबाइल का एयरटेल नंबर सचिन एवं जियो नंबर सचिन लगा हुआ है एवं कमर के पीछे छिपाया हुआ जियो मोबाइल नंबर 799 का सीरियल नंबर. रोहित मंडल के पहने हुए जींस पैंट के बाएं पॉकेट से आईफोन मोबाइल सेट IMEI नंबर सचिन से जिसमें मोबाइल नंबर 773940777732 लगा हुआ है. रोहित मंडल के पहने हुए जींस पैंट के बाएं पॉकेट से पैन कार्ड शंकर सचिन से धारक रोहित कुमार मंडल. पंजाब नेशनल बैंक ATM कार्ड धारक रोहित कुमार मंडल. बैंक ऑफ इंडिया ATM कार्ड धारक रोहित कुमार मंडल एंड इंडिया पोस्ट पेमेंट कार्ड जिसका अकाउंट नंबर धारक रोहित कुमार मंडल. And in person in the case diary it has been stated that here it belongs to one Bablu Roy of West Midnapur. Neither Bablu Roy has been made as a charge sheet witness.
Your mobile has been found linked with 13 bank accounts. They all belong to you?
13 but is
They all
there
belong to you?
13 bank accounts. My lord, those bank account details has not been given. Details are given, my lord, but not even a single person has came forward and said that I have been cheated, my lord. And e-wallet, there is no e-wallet transaction, my lord. E-wallet transaction, my lord. If
Pura list of transactions, sir.
it's not
Para 61.
61
Yes,
में
para
दिया है.
61 में list of transactions, sir. How many?
But madam, that transfer has been used in cybercrime or not?
82 transactions.
That has been used in cybercrime or
That's
not?
right.
That
And
has to be
then-
verified.
And
By
then,
the-
so, you see, there are 13 accounts which are linked to
Yes.
your, not a case.
But I have 13 accounts, whether that has been for cybercrime that I have used it, there should be some evidence during investigation.
Some evidence is there.
Some
अभी
evidence.
सुनेंगे उनको तब आपको
Mere
पता
suspicion
चलेगा.
and grave suspicion.
We
my
will
lord.
see that. हाँ बताइए.
Lordship, there are 191 transactions through UPI Lordship, that is described in para 61 also. Para 61. रोहित मंडल के पास से बरामद बैंक ऑफ बड़ौदा के एटीएम कार्ड से संबंधित खाता संख्या इतना बैंक स्टेटमेंट इतना खाता
And these transactions were being done through these mobile and SIM.
Yes, the ATM, जो ATM
ATMs.
that बैंक अकाउंट का स्टेटमेंट से 191 यूपीआई ट्रांजैक्शन पाया गया, that is 61,30,820.
यहाँ पे जो है, there is a transaction of 61 lakhs for, and now in the remaining is 9,000 something. Now all these UPIs, it has been deposited in my account, and then again withdrawn. So all these UPI transactions are to a victim or not, that has to be seen, my lord. Because otherwise my chance of conviction is very bleak. Because in cybercrime, although they are remaining in custody for 5 years, 4 years, but the conviction rate is very less, man. Whatever from 2017 onwards, I am saying it, madam. The conviction is very less. Ultimately, the investigation depends upon the court who is hearing a bail application, madam. Earlier it was e-wallet. Now the court who was hearing earlier was searching for a victim, and now they are saying the victim has come, and that also through telephonically. That telephonically I have taken 161. That victim never comes down in the court and says, and ultimately acquitted. These are the things, my lord, that all these UPIs have been connected with my account, and these transactions are due to a cybercrime. I have achieved these illegal money through doing cybercrime for attracting 419, 420. And that is parameter to 65 BCD, and that is valuable in nature. And 81 is an overriding clause. Only on these parameters I was saying that if one person has been granted enjoying the privilege of bail, where there is a victim also, and I.
वो order कहाँ चला गया थी?
Yes, Lord. Forgotten now.
जो फर्स्ट वाला में डिस्क्राइब किया, एक केस पहले वाला में जो डिस्क्राइब किया था इससे, दोनों सेम केस.
इनका WhatsApp chat भी तो है.
WhatsApp chat है para 108.
108 में पूरा WhatsApp chat है. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner has submitted that.
एक और हम para 69 में लॉकअप फॉर्मली सारे सीज मोबाइल नंबर का क्राइम लिंक किया हुआ है 3700.
Page number?
That is 69, para 69.
WhatsApp है debited, debited, credited, debited. The WhatsApp chat is credited, debited.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since 26/8/25.
Yes.
The charge sheet has been submitted on 19/11/2025.
Yes, my lord. It's in the stage of police papers.
And so far as charge has not been framed.
Yes.
He has submitted that 3 mobiles, 4 SIMs, and certain ATM cards have been recovered from the petitioner, and there is no material on record to link the petitioner with the cybercrime. The learned counsel has referred to the order dated 8/12/2025 passed in BA number 10027/25, by which one co-accused, namely Hogan Dan, has been released on bail.
2 mobile sets, my lord, not 3.
Two mobile
Two
sets.
mobile
Sorry,
sets.
two mobile sets,
and 4 SIMs.
4 SIMs. The learned counsel for the opposite party has opposed a prayer for bail and has submitted that out of 4 SIMs, the 2 SIMs were standing in.
Only 1 SIM. 1 SIM, 2 SIM. No, belongs to other person.
2 SIMs belongs to other person.
2 SIMs belong to other persons, to which the petitioner has no explanation. The learned counsel submits that the mobile and the SIM were used for commission of cyber offence. He has referred to the WhatsApp chats which has been recorded in para 108 of the case diary, and has also referred to paragraph 69 of the case diary to submit that the entire chart has been mentioned therein. The learned counsel submits that the case of the petitioner is the learned counsel has also submitted that the various transactions have been brought on record.
One mobile in there.
One mobile, only one mobile.
Only 1 mobile. That I was saying, my lord.
And one mobile in the name of
Others.
others.
Only 1 mobile.
2 SIM in the name of others and 1 mobile in the name of
नहीं
others.
नहीं SIM जो लिखवाया गया था 1 SIM in there.
एक ही
अरे
SIM
मैं
है जो
इतना confusion
एक ही हम बोल रहे थे मान ही नहीं रहे थे ना प्रॉब्लम वो है हम देख के रिकॉर्ड देख के
कितना
बोलते हैं।
मोबाइल रिकवर हुआ?
2 मोबाइल सेट रिकवर हुआ
2
4
मोबाइल
SIM हुआ।
और 4 सिम हुआ।
4 में से 1 SIM दूसरे के नाम से।
1 सिम और मोबाइल सेट इनके नाम से है नहीं पता।
मोबाइल सेट कर दिया।
और वो सिम पीछे घुसाया हुआ है।
That's it. And 2 mobile, 4 SIM and 1 SIM in the name of another person.
And he has not been made as a charge sheeted witness. That may be observed in my submissions. That it is the name of Bablu Roy, son of Radha Krishnan Roy of Midnapur, and he has not been made as a charge sheeted witness. That in my submission that may be recorded.
ऊपर लिखिएगा, the learned counsel for the petitioner has submitted that 1 SIM was in the name of Bablu Rai, who is a resident of Midnapur, and he is not amongst the charge sheeted witnesses. The counsel for the state has submitted that the numerous transactions and WhatsApp chats have been mentioned in the case diary, and during the period from 26/8/24 to 26/8/25, an amount of rupees 61,40,374 was deposited through various UPI transactions, and during this period total 61,030 the 61,30,820 was also withdrawn. The WhatsApp chats have also been placed on record. After hearing the learned counsel for the parties and considering the materials on record, including the WhatsApp chat and the fact that the petitioner, that one mobile SIM or standing in the name of different person has been recovered from the petitioner, to which the petitioner is unable to account for and has no documents in support of such possession. This court is of the view that the petitioner is not entitled to be released on bail. The case of Khogen Dan, as is apparent from the order granting bail, stands on different footing. The counsel for the state has submitted that the state shall take all steps for prompt production of witnesses. That is saying, communicate. Rejected.
Item 14 PA 10624 of 2025.
Yes.
Custody seems not say custody number. Also, if we look at
What is the date of custody?
3/8/23
ट्रायल का क्या हुआ?
ट्रायल में हम लोग ये चार्जशीट हुआ है और गवाह लोड नहीं हुआ।
आपके खिलाफ चार्जशीट कब हुआ?
ये किसमें नोटिस नहीं टाइम दे दीजिए बता दें।
जो चीज नहीं पता उसके बारे में क्या टाइम है? स्टेज ऑफ प्रोसिक्यूशन विटनेसेस। क्या मैटर है आपका?
इसमें जो मेरे कन्फेशन से बोला गया है कि इसमें इसका कन्फेशन में नाम आया, किसी कन्फेशन से नाम आया उसका भी बेल हो गया है 108/2/25।
केस बताएंगे आपके अगेंस्ट में क्या एलिगेशन?
मेरे अगेंस्ट नहीं एलिगेशन है कि पुलिस मेरे कन्फेशन से आर्म्स रिकवर किए छुपाया हुआ था, बट पुलिस विटनेस है कोई इंडिपेंडेंट विटनेस नहीं, 8 साल से ऊपर कस्टडी हो गया है और कोई भी जिसके आर्म्स रिकवर हुआ उसका भी बेल हो गया है। इनसे 2 सीरीज हो जो 28 से लेकर 30 तक।
आप ऐसा इतना वेग क्या एलिगेशन है आपके ऊपर? कौन सा सेक्शन पे केस है?
कि मेरे कन्फेशन से जहां सामान आप छिपा के रखा गया था वो रिकवर।
सिर्फ आर्म्स एक्ट का केस है कि और भी सेक्शंस है इसमें?
और सेक्शन मेरे पर तो लेवल लिखा हुआ है फाइल में, बट मेरे पास एलिगेशन हुई है।
स्टेट साइलेंट है, अभी फाइल पड़े। क्या एलिगेशन है इनको?
इसमें 413 है।
ये पुलिस उपाधीक्षक नीरज कुमार के ऊपर फायरिंग हुआ था, घटना हुआ था, उसी क्रम में जांच के क्रम में ये पकड़े गए हैं। इनका एक एंटीसीडेंट है और इन्हीं के कन्फेशन पे राजन कुमार को भी अरेस्ट किया गया, जो कि
उसका भी
और उनके इसके बाद जो है ईटा भट्टा।
कोई बात नहीं, आप जरा एफआईआर पढ़िए।
हाँ,
आप कहानी नहीं सुनाएंगे, हम एफआईआर पढ़िए, पूरा पढ़िए एफआईआर, पढ़िए पूरा एफआईआर पढ़िए।
इसमें मुझे लगा कि
आप पूरा पढ़ जाइए, बीच में कोई कमेंट मत करिए।
उपरोक्त विषय के संबंध में कहना है कि मैं पुलिस अवर निरीक्षक रघुनाथ सिंह थाना प्रभारी पतरातू जिला रामगढ़ के पद पर पदस्थापित हूँ। आज दिनांक 19/7/23 को आतंकवाद विरोधी दस्ता झारखंड रांची थाना कांड संख्या 7/23 दिनांक 18/7/23 धारा 353, 332, 333, 307, 120B भारतीय दंड विधान 27 आयुध अधिनियम एवं 16/17/20 विधि विरुद्ध क्रियाकलाप निवारण अधिनियम 1967 में लोहरदगा के भंडारा थाना अंतर्गत ग्राम भरों से गिरफ्तार अभियुक्त सिद्धार्थ कुमार साहब उर्फ बाबी साहब, पिता कलेश्वर साहब, साकिन टेरपा, जाटोला, थाना पतरातू, जिला रामगढ़ से पूछताछ के दौरान इनके द्वारा अपने दोस्त वाले स्वीकारोक्ति बयान में बताया गया कि रांची जिला रोड़ा थाना कांड संख्या 261-23 एवं दिनांक 17/7/23 को रामगढ़ जिला पतरातू थाना क्षेत्र अंतर्गत आलू डायरेक्टिव मोहर नजदीक आतंकवादी विरोधी दस्ता के पुलिस उपाधीक्षक श्री नीरज कुमार एवं अन्य के ऊपर घटित फायरिंग की घटना में प्रयुक्त मोटरसाइकिल सुजुकी रिक्शा एवं नाश्ता मेरे पिस्टल मेरे छोटे भाई राजन कुमार एवं रवि मुंडा प्रसादी मुंडा साकिन टेरपा थाना पतरातू जिला रामगढ़ की जानकारी में मेरे पिता कलेश्वर साहब के टेरपा छोड़ा टाण अवस्थित बंगला एक भट्टा में आसपास छिपाकर रखा हुआ है, इसे मैं चलकर बरामद करा सकता हूँ। गिरफ्तार अभियुक्त सिद्धार्थ कुमार को भोगी साहब के 2 स्वाकृति बयान में उल्लेखित तथ्यों के सत्यापन एवं आपराधिक घटनाओं में प्रयुक्त मोटरसाइकिल एवं अग्नास्त्र बरामदगी के हेतु पुलिस पदाधिकारी को सूचित करते हुए गठित टीम एवं एटीएस के पदाधिकारी एवं बल के साथ पतरातू थाना से करीब 21 बजे प्रस्थान किया। ग्राम टेड़पा आजादपुरा में बजरंगबली मंदिर के पास सिद्धार्थ कुमार उर्फ बाबी साहब की निशानदेही पर राजन कुमार तथा कलेश्वर साहब, साकिन टेड़पा आजादपुर पतरातू जिला रामगढ़ को पूछताछ हेतु रोका तो छानबीन के क्रम में अन्य कोई ग्रामीण साक्षी के उपस्थित नहीं रहने के कारण पतरातू थाना सुरक्षित बल के आरक्षी अरुण कुमार महतो एवं प्रदीप कुमार दास को साक्षी मानते हुए अपना तथा अपने साथ के पुलिस पार्टी की तलाशी देकर तलाशी नियमों का पालन करते हुए तलाशी लेना प्रारंभ किया। तलाशी के क्रम में राजन कुमार पिता कलेश्वर साहब
आपकी निशानदेही पर रिकवरी है ना?
हर सबसे कस्टडी में हो गया है, अब उधर कंडीशनल पार हो गया
नेक्स्ट पेज
मैक्सिमम
रिकवरी में देख लिया जाए। पेज नंबर 21 में फोर्थ लाइन में एक 21 फोर्थ लाइन एक प्लास्टिक की झोले में रखा हुआ एक स्वचालित 7.65 mm का लोडेड पिस्टल जिसके बट की लंबाई 5.5 इंच, बैरल की लंबाई बट की बैरल की कुल लंबाई 100, एक अर्ध स्वचालित 9 mm का लोडेड पिस्टल जिसके बट की लंबाई 100, बैरल की लंबाई 100 से बैरल की लंबाई कुल लंबाई 100, एक स्वचालित 7.65 mm लोडेड पिस्टल के बट की लंबाई 100, बैरल की लंबाई 100, बैरल की कुल लंबाई 2 लोहे का 7.65 mm का खाली मैगजीन बरामद हुआ।
और एक बात बताइए, ये नीरज कुमार और अन्य कौन है? ये पुलिस ऑफिशियल है इनके
ये तो लिखा हुआ है नीरज कुमार उपाधीक्षक, पुलिस उपाधीक्षक से नीरज कुमार
पुलिस पर फायरिंग किए थे आप?
उसमें मुझे
ऐसा एलिगेशन है?
ऐसा एलिगेशन में बेल में है, 87-23 का केस है, उसमें बेल हो गया है डबल बेल से।
उसमें आपका कन्विक्शन के बाद बेल हो गया?
नहीं, कन्विक्शन के बाद नहीं,
डबल बेल एटीएस मतलब स्पेशल एक्ट में होगा बेल।
हां, स्पेशल एक्ट में उसमें बेल में।
इनका एक्सीडेंट कहाँ है?
पीछे में लास्ट पेज में further he is member of gang of Aman Sahu and he has criminal antecedent of 8 cases.
8 cases.
इसमें जो एक्सेप्ट दिस केस ऑल आर ऑन बेल है।
अच्छी बात है। अच्छा है, जेल में रह के अपना सारा ट्रायल कंप्लीट करा।
सब में बेल में मुझे इसमें कुछ नहीं है।
देखिए
इसमें नहीं, सिंपली विड्रॉ कर दिया जाए।
नहीं,
सिंपली विड्रॉ कर दिया जाए।
आफ्टर सम आर्गुमेंट व्हेन दिस कोर्ट वाज नॉट इन टाइड अप ऐसे ही रहेगा। सिंप्लिसिटी विड्रॉल में भी टाइड अप रहता है। आपको क्या लगता है बेंच हंटिंग चलेगा यहाँ पर? सिंप्लिसिटी विड्रॉल में भी टाइड अप रहेगा। लिख दे, नहीं देखिए पीए नंबर 10624 of 25. The counsel for the petitioner has argued the case after some argument when this court was not inclined to enlarge the petitioner on bail. The counsel for the petitioner seeks permission to withdraw his bail application. Accordingly, this petition is dismissed as withdrawn. चलिए नेक्स्ट। हम पता किए हैं सिंप्लिसिटी विड्रॉल भी टाइड अप रहता है। आप लोग गलत फहमी में मत रहिए। आपका ड्यूटी है, अगर इसमें से किसी में भी हमको सिंप्लिसिटी विड्रॉल दिख जाएगा ना कोई भी कोर्ट का जो अवेलेबल कोर्ट होगा, एक रिकॉर्ड है इसमें हमको, क्योंकि हम सुबह फाइल देख रहे थे, इसमें एक रिकॉर्ड इसमें जरूर है जिसमें ऑनरेबल जस्टिस राजेश कुमार के यहाँ से विड्रॉल बेल दिए है। क्या पास ओवर है ना? नहीं, उसको एप्रोप्रिएट बेंच हम नहीं। सीरियल नंबर 4 बताइए तो। सीरियल नंबर 4 में counsel for the petitioner has submitted that the bail application of the petitioner was placed before a coordinate bench, and prayer for bail, and the bail application was withdrawn. Office is directed to place this case before the appropriate bench after taking prior permission of Honorable the Chief Justice. हम इसमें बहुत पूछताछ के आए हैं, क्योंकि जब हम देखें तो हम बहुत दिन हो गया, बेल तो हम कभी किए नहीं
जाएगा वहीं पर।
बहुत अच्छी
सारे कुछ का बेल
कोई बात नहीं, हो गया ऑर्डर, विड्रॉ कर लिए हैं, शांति से रहिए। नेक्स्ट
Item 15, VA 10646 of 2025.
Receive application for grant of regular pay under section 103, innovated 1, 238, 305. That is not a BNS. Railroad decision under section 302, 201 and 34. In this case, there is no evidence about the whole case in the account of the confessional statement of the accused persons, except that there is nothing in it. But the story narrated in the FIR is not that not the brother of the deceased, namely Subhash Kumar, the FIR was lodged on 3/4/8/2025, alleging therein that in the night of 1/8/2025 at 9:30 p.m., the informant brother, who is not the deceased, Subhash Kumar, had left his house. He did not return not in the house. Then on 3/8/2025, he received information that not the dead body of not his brother and not one not the girl, who are not very 22 years and 21 years, both are having love affair, were found in a well. Thereafter, not the case not has been registered against Lord Upendra Mahato and not his family members. Upendra Mahato is the father of Lord the girl and not the family member. So, except not this FIR which has been lodged not by the witness who is not the eyewitness. The present petitioners not are the brothers of not the father of not the deceased lady, deceased girl.
brothers of Upendra Band.
Yes, not the petitioners are not the uncles of not the girl. And in this case, not there is logic. There was not the during the course of investigation, the only not the confessional statement was recorded, in which it has come as that not this the deceased was at about not the 22 years and not the girl aged 21 years. They were having not the love since long. The marriage of not the this not the girl was fixed in Chhattisgarh. Sometimes not the prior to the result. Even then, both were not the seen talking and maintaining not the love affair. In the fateful night of not the 1/8/2025, the girl not she had left her house without informing anybody. In the night not at 11 p.m. This has come not the confessional statement. Only there is
Any recovery from you?
No, there is no recovery at all. There is no confessional statement of not the petitioner.
There is no confession statement of the petitioner also.
There is no confessional statement. There is no recovery at all. Only not the name has been transferred in the confessional statement of not the father and mother of the deceased one that has got no basic value in the law. And when the both were returned, not both charges has been submitted.
Your statement has not been recorded
No,
by the
ma'am.
police.
No, the diary is here.
अरे भाई इनका स्टेटमेंट नहीं रिकॉर्ड हुआ है और पहले से कर दिया है, उसके बाद इनका स्टेटमेंट नहीं रिकॉर्ड किया। Are you sure about this? ऐसा होता है क्या? Eyewitnesses are there.
No.
Eyewitnesses not there.
Only
Witnesses are supported that मतलब शादी की होने के बाद ही ये दोनों का मिलना जुलना होता था, इसलिए इनको बुला के और सबके द्वारा इनको मार दिया गया और सबको वहाँ फेंक दिया गया।
कोई आई विटनेस है?
आई विटनेस नहीं है और दोनों का वो पोस्टमार्टम रिपोर्ट है, मतलब two diseases are there. एवं death is due to blood injury and its associated complications. ये सुभाष कुमार का है और विभा कुमारी जो लड़की है उनका उसका है due to asphyxia as a result of antemortem drowning.
Antemortem drowning. Already before not the death, not see was not the already immersed in
I
it.
think it's not there, but mechanism supported that दोनों एक दूसरे से बात करते हैं इसी बात का गुस्सा से इस समय पर अपने सर्टिफिकेट वाला दोनों को मार दिया
चार्जशीट तो हो गया होगा आपका
हाँ,
ट्रायल
चार्जशीट
चल
हो
रहा
गया।
है। You are under trial?
जी
You are under trial now?
Notice after submission of charge sheet not the charge not has not been clear. Charge sheet has been submitted on 29/10/25 and not there in jail custody since 4/8/25.
Charge sheet has been submitted on
29/10/25
आप कस्टडी में कब से हैं?
4/8/25. And there is no, they have got no criminal incident. Only not the reason that they are not the uncles, not they have got no not the involvement. Only not the name has been transferred on legal contact. Suspicious. तो लगता है अभी सुसाइड
You are named in the FIR also?
Not the basis of suspicion only.
Yes, sir.
Suspicion only. But may I read not the FIR? करीब एक दूसरे प्रेम करते थे करीब 13 महीने पहले उपेंद्र महतो ने फादर नॉट द पिटिशनर नॉट है नॉट द आस्क एनीथिंग नॉट द टू बी डिसीज कि हम बात मत करो कोई इन्वॉल्वमेंट ही नहीं खाली पूरा जो है सो उनके जितने भाई लोग हैं सबका जो है कि कर दिया गया और ये लड़की को दबाव देकर बुलाया गया ये कहीं भी एविडेंस में नहीं आया कि कोई फोन हुआ हो या कोई देखा हो इन लोगों को लिया
DA number 10646 of 2025 for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the informant is the brother of the deceased who has stated that and the FIR has been lodged on 4/8/2025. The informant stated that on 1/8/2025, his brother, within that deceased, left home and did not return back. And in the FIR, it is alleged that he was having love affair with daughter of Upendra Mahto, and Upendra Mahto and his brothers had tried to counsel both the persons. It has been alleged in the FIR that the body of the boy and the girl, aged 22 and 21 years, was recovered from the well, and upon recovery of the body, the FIR was instituted. The learned counsel submits that there is no eyewitness to the occurrence, and the name of the petitioner has come in the confidential statement of the co-accused. He has also submitted that the marriage of the girl was already fixed at Chatra, but still the boy and the girl continue to have relationship. The learned counsel has also submitted that except circumstantial evidence, there is nothing against the petitioner. Except confession statement of the co-accused, there is nothing against the petitioner. The charge sheet has been submitted on 29/10/25, and the petitioner is in custody since 4/8/2025. The learned counsel for the state has opposed the prayer and has submitted that the petitioner is named in the FIR, and there is every motive for the petitioner to commit the offence. Petitioners. There is every motive for the petitioners to commit the offence, as their daughter, as the daughter in their family was involved in the affair with the brother of the informant. However, during the course of argument, she has not been able to point out any eyewitness or any material from the case diary except the confession statement of co-accused. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and the fact that it appears and the fact that no material except confession statement could be pointed out by the learned counsel for the state, the petitioner is directed to be enlarged on bail. कंडीशन हम लोग का सेम रहता है, हम लोग का सेम कंडीशन रहता है. जो आपका पैमिक कार्ड है वो आपका पेबल बनेगा. You have to attend on every date.
Item CK BA 10679 of 2025.
Yeah, please. This is an application for grant of regular bail in a case registered under several sections of the DNS law. The corresponding sections, the main section is 307-386 of the IPC.
Corresponding.
Yes, yes. Lord, charges have been framed and Lord, I'm in custody since 5/3/2020.
Theft in dwelling house.
Lord,
Theft in dwelling house with 307.
Lord, 307 basically, Lord, the case of the prosecution is that, Lord, when the informant, who happens to be a truck driver, when he went, Lord, to load cement over on the truck, Lord, some unknown miscreants came there and Lord assaulted the informant as well as one other person and demanded 20,000 rupees. Now, Lord, the first information report has been lodged
Were
against
you apprehended on the spot?
No, it has been, the FIR is against unknown miscreants, only on the basis of confession of
Any you have been put under TIP?
No, Lord, I have stated, without putting me on TIP, Lord, the charge sheet has been submitted. And Lord, one of the similarly situated on the basis of this only has been granted regular bail, Lord, by coordinate bench that I have annexed.
On the last occasion, criminal antecedent of this case was recorded. And as per report, there are 8 criminal antecedents.
Lord, save and accept criminal antecedents so far this case is concerned, there is absolutely no material. No TIP, Lord.
All are of similar nature.
Two witnesses have been already examined.
Two witnesses have been examined.
If you know that it is a
The informant has been examined and he has not supported the case. That has come in the.
Who has not supported the
The
case?
informant of this case, Lord. Has been examined as PW1, it has come in the.
Hostile?
Not hostile, Lord. Not hostile.
That's come in the impugn order. And out of 5 charged witnesses, 1 has been examined. This order is of September 25. I have verified from e-court status.
One more.
I have verified from e-court status, and 1 more was also examined.
2 witnesses are
3 witnesses are required.
Out 3 already.
3 are required to be examined.
3 more.
3.
3 में से एक तो आईओ ही होगा.
एक
और एक कोई होगा.
ऑफिशियल विटनेसेस ही होंगे.
307 सारे ऑफिशियल विटनेसेस ही होंगे.
ऑफिशियली होंगे क्योंकि कोई आई विटनेस नहीं अगेंस्ट अननोन था. Lord, there is very less, Lord, likelihood that Lord, the prosecution can, Lord, secure conviction in this case because without putting the petitioner on TIP, Lord, charge sheet has been submitted and exactly similarly situated has been granted. Save and accept confession and Lord, the antecedent that has been pointed out by my learned friend, there is no material.
What's the name of the petitioner?
Akash Sharma.
Criminal antecedent is at para 135.
Para 1, इसमें तो para 135 है ही। अच्छा ये चीज़ है। Para 1 ना आपका criminal antecedent है, सब एक जैसा है, सब arms act से related।
होता क्या है मिलोड, इसमें जितने भी केसेस हैं कन्फेशन के अलावा कुछ भी नहीं, ओनली ऑन द बेसिस ऑफ मिलोड द कन्फेशन ऑफ 4 accused persons आई हैव बीन देयर, ऑल आर अगेंस्ट अननोन मिलोड, एंड आपको पकड़ लिए हैं एक केस में और हर केस में रिमांड कर रहे हैं ओनली ऑन द बेसिस ऑफ मिलोड कन्फेशन, सेव एंड एक्सेप्ट कन्फेशन। इस केस में भी कुछ नहीं है, entire diary मिलोड, I have gone through the entire diary, मिलोड single also मिलोड पे मिलोड not even a single material has been brought on record by the prosecution without putting मिलोड the petitioner on DIP charge sheet has been submitted, there is no other cogent material against me, मिलोड only on the basis of मिलोड criminal antecedent मिलोड conviction cannot be secured।
आपको पकड़ा कैसे?
हमको कहते हैं कि मिलोड one of the co-accused person was apprehended और उनके कन्फेशन में मेरा नाम आया,
Who was the co-accused person?
मिलोड who has been granted bail, मिलोड बंटी कुमार।
Banti Kumar, he is the first person to have been arrested.
ये इंस्ट्रक्शन तो नहीं है, बट सो फार मिलोड पिटिशनर है उनका आया है इसमें। And I mean मिलोड custody with respect to one other case मिलोड, उस केस से फिर ऊपर मिलोड
का नाम पूछा है,
आकाश शर्मा।
आपका स्टेटमेंट नहीं रिकॉर्ड?
Yes, Dr. उनका statement है at para 86, and this incident is dated 29/11/2024, and in the confessional statement it is dated 29/11/24, para 85 first page second part. राज्य क्षेत्र दिनांक 29
this statement is concerned, this has also not got any evidentiary value because nothing has been recovered.
आपका एक्यूटल का तैयारी कर लीजिए।
तो इसमें जो एक मिनट न्याय प्रयोग की बात है, स्टेटस में भी कॉल्ड फॉर बिकॉज़ इसलिए हम लोग कह रहे हैं क्योंकि ऑलमोस्ट मिनट 7 महीना हो गया।
आप बताइए, सारे ऑफिशियल विटनेस हैं, सबका गवाही एक के बाद एक करा देंगे ना, बस करा देंगे।
7 महीने में एक करा पाए
सब कराएंगे, ऑर्डर होने का सब कराएंगे। बहुत आपका बैकग्राउंड बहुत खराब है, सेम तरह के ऑफेंसेस इतने सारे हैं। You belong to a gang. That is the allegation. Allegation is that you belong to a gang who is involved in such kind of offense.
So as for 17 CLA has not been blown.
17 CLA है?
नहीं
है।
चार्ज जो फ्री चार्ज शीट तो सबमिट हुआ उसमें नहीं है। अदर केसेस का मिलोड इससे क्या है?
वो बात।
और मिलोड सेव एंड एक्सेप्ट मिलोड क्रिमिनल एटलीस्ट मिलोड जो ट्रायल का स्टेटस मंगवा लिया जाता सो दैट एक्सपेडाइट हो जाए ट्रायल। Well, I am already in custody. I am not running away. मिलोड मेरा ट्रायल कंक्लूड कर दे, वो भी नहीं करते हैं।
दूसरे केस में आप कस्टडी में हैं?
हाँ कस्टडी में, जो आज ही मेरा एक रिजेक्ट हुआ है।
तो जब आप दूसरे केस में कस्टडी में हैं तो फिर इसमें बेल लेके भी क्या करेंगे?
But my lord, still, my lord, my fundamental right, my lord, under Article 21 is infringed, my lord, by
That is
keeping.
not going to serve any purpose because you are
That
already
is
in
there, my lord,
custody.
I am in custody, that is there, my lord, I am not denying, but my lord, the only fact, my lord, that remains, my lord, is that in 7 to 8 months, only one witness has been examined. और इस पेज पे तो हुजूर अभी
नहीं,
दो
अभी
ढाई
आपका
साल
सारा विटनेस एग्जामिन करा, ठीक है? For the learned counsel, you just wait. BA number 10679 of 2025. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner has submitted that except confession statement of the petitioner, there is no material against the petitioner. He has submitted that the allegation is that while the informant and his colleagues were going to load cement dust on the vehicle at the place of alleged occurrence, 6 miscreants came there and assaulted the informant with torch. And butt of arms over their head, leading to profuse bleeding. The accused persons were making demand of levy and extortion and forcefully snatched rupees 20,000 from a mobile phone and challans and set fire Tata Turbo truck bearing number JH01DK437 and fled. The learned counsel has submitted that for last 7 months, no witnesses are being produced. Only one witness has been produced by the prosecution.
As per report status report, 2 witnesses
The counsel for the opposite party has opposed the prayer and has submitted that the criminal antecedent of the petitioner was called for and he has as many as 8 criminal antecedents of similar nature. He submits that the petitioner belongs to a gang of persons who are involved in extortion. He has submitted that as per his report, 2 witnesses have already been examined and 3 are remaining to be examined. And most of them must be the official witness. He has also submitted that the prosecution shall ensure prompt production of witnesses. After hearing the learned counsel for the parties and considering the fact that trial is in progress and the petitioner has numerous criminal antecedents of similar nature, this court is not inclined to enlarge the petition on bail. However, the counsel for the state has undertaken that the witnesses will be promptly produced before the court. The counsel for the state is directed to communicate this order to the concerned authority to ensure prompt production of witnesses.
May I only say one thing? My submission only one thing made important without putting the petitioner on TIP.
He has also submitted that the petitioner has not been put in TIP and there is no likelihood of conviction of the petitioner.
Much of this.
Item 17 BA 10691 of 2025.
The offense is 103161 BNS. As with the FIR note, it is stated that the shop of the petitioner Rahul Das, who accused and the deceased was decided at the same place, and there was warrant between them for which he had written. And apart from confession, there is nothing. The confession of Rahul Das is paraphrased. He has confessed कि जो है कि deceased used to touch the body of his girlfriend and he was teasing his girlfriend. Therefore, he has committed murder, and he had after committing murder, he had gone to the house of the petitioner, who had provided him clothes and other things. only this is this there is in the confession there is no participation of the petitioner in the commission of murder. It is admitted that Rahul Das.
Anything recovered from you?
No, nothing. Rahul Das ke confession पर that chopper has also been recovered. Rahul Das has confessed that he has committed murder, and thereafter he went to my house. I had provided him the clothes, and the blood-stained clothes were burned. This is the nothing. And the petitioner has got no criminal antecedent. Only that he is the friend of Rahul Das, and it is said in the FIR that 2 days back he was also there.
You were involved in destruction of evidence.
Yes.
Where is the confession statement of
Para
Rahul Das?
14.
Para?
14. Rahul Das. There are 14 maybe.
Yes.
One more important thing in this case. There is a tower location at the time of incident. The investigation team has recorded the CDRs and mobile phone of the deceased and
Petitioner.
petitioner.
They were found at the same location?
Yes, that I will clarify. My house is beside the place of occurrence. That is in the as per my location is from my house. The CDR तो एक जगह का एक location है Jharkhand High Court. My house is beside the place of occurrence, and as per confession para 14 it is said.
पढ़िए para 14.
Yes. मेरा नाम राहुल दास, उम्र 21 वर्ष, पिता सूरज दास, करमाल के पीछे प्रमोद सिंह के मकान में किराएदार, थाना सुनारी, जिला पुलिस जमशेदपुर है। आज दिनांक 6/3/25 को समय करीब 9 बजे रात में कपाली ओपी के पुलिस पदाधिकारी के समक्ष बिना किसी डर भय या प्रलोभन का जानते हुए कि मेरे द्वारा दिया गया बयान मेरे विरुद्ध न्यायालय में साक्ष्य के रूप में प्रस्तुत किया जा सकता है, बयान दर्ज कराता हूँ कि मेरी 30 तक पढ़ाई किया हूँ। मेरा सुनारी थाना अंतर्गत बिंदल मॉल के पास चाय का दुकान है। मेरे दुकान के पास में ही शिवम कुमार सिंह एवं उसका भाई शुभम कुमार सिंह का चाय का दुकान है। दोनों भाई अक्सर मेरे दुकान पर आकर मेरे साथ गाली गलौज करता था एवं मेरे ग्राहक को भी भड़का देता था। करीब 4-5 महीना पहले शिवम कुमार सिंह ने मेरा किसी बात को लेकर झगड़ा हुआ था।
इसका क्या नाम है?
शिवम कुमार सिंह।
ठीक।
झगड़ा हुआ था, तब झगड़ा के अगले दिन शिवम कुमार सिंह का बड़ा भाई शुभम कुमार सिंह मेरे घर आया और मेरे साथ गाली गलौज एवं मारपीट किया। मेरी एक गर्लफ्रेंड है जिसका नाम पूनम है, जो सोनाली में रहने वाली है। उसको भी शिवम कुमार सिंह बार-बार गलत तरीका से छूता था एवं जबरदस्ती उससे बात करता था। तब मेरा गर्लफ्रेंड पूनम के पापा को भी मेरे खिलाफ भड़काता था। कुछ दिनों पहले ही शिवम कुमार सिंह ने मेरी गर्लफ्रेंड पूनम के पापा को मेरे विरुद्ध भड़काया था, जिसके बाद मेरी गर्लफ्रेंड पूनम के पापा उसके साथ बहुत मारपीट भी किए थे। इन सभी बातों को लेकर हम बहुत डिप्रेशन में आ गए। तब मैं शिवम कुमार सिंह के साथ बदला लेने की तरकीब लगा रहे थे। बदला लेने के भावना में आकर हम शिवम कुमार सिंह के साथ बातचीत करना शुरू किए और 2-3 दिन से हम और शिवम कुमार सिंह के साथ बैठकर शराब पी रहे थे। दिनांक 5/3/25 को भी हम शिवम कुमार सिंह को कॉल किए और शराब पीने की बात बोले, तब मेरे पास आया। उसके बाद हम दोनों सुनारी में ही शराब, कोल्ड ड्रिंक, पानी, सिगरेट एवं चखना ले लिए। उसके बाद हम अपने स्कूटी नंबर 16 एवं शिवम कुमार सिंह बाइक से समय करीब 16 बजे कपाली के करमगोड़ा के पीछे
जंगल में चला गया। आपके घर के बगल में कहाँ है?
वही पर मेरा घर है।
जंगल
के वही जो टावर लोकेशन है वो कपाली दिखा रहा है। कपाली में ही मेरा घर है।
कपाली टावर लोकेशन रांची दिखाएगा तो
हाँ, yes, ये
is a huge area.
हाँ, yes, वही
That's a huge area.
yes, that टावर लोकेशन भी ये कपाली दिखा रहा है और ये कह रहे हैं ये भी है आया है कि जो टावर लोकेशन जो है, मेरा डिसीज के साथ कोई बात नहीं है, डिसीज और शिवम कुमार और राहुल दास के साथ बातचीत हुआ है। और उसके आगे पढ़ देते हैं, हत्या कर दिए और चापड़ को वहीं आगे जाकर नाला के पास फेंक दिए। शिवम कुमार सिंह को चापड़ से मारने के क्रम में मेरे बाएं हाथ का 3 अंगुली भी कट गया। उसके बाद हम वहां से अपने दोस्त नाउ दैट रोल हैज कम मोहम्मद आसिफ, जो कपाली अंतर्गत डेमदुबी का रहने वाला है, के पास चले गए, उसको सारी बात बताए। तब मोहम्मद आसिफ अपना कपड़ा पहनने दिया और हम अपना कपड़ा को अपनी स्कूटी के डिक्की में रख लिए और वहां से पुलिया रोड होते हुए मांडो पहुंचे और मांडो पुल के पास अपना कपड़ा को और मांडो नदी में फेंक दिए। और
तो ये आसिफ का मोबाइल लोकेशन आया है सर?
नहीं, उसका
कहाँ है बताइए?
यस, मोबाइल लोकेशन मेरे साथ नहीं है, वो
कोई बात नहीं,
कपाली
देखते हैं।
यस।
कहाँ है इनका आसिफ का मोबाइल लोकेशन?
51 para 52 of the case है। सबकी 2000
हाँ
ऊपर से सेकंड पैराग्राफ में
हाँ
प्राथमिक अभियुक्त मोहम्मद आसिफ खान का मोबाइल नंबर सर्च का सीडीआर और होगा। प्राथमिक अभियुक्त आसिफ खान का मोबाइल नंबर का दिनांक 5/3
हाँ
को समय 19 बजे, टावर लोकेशन सोनारी एवं समय 8 बजे 19:54 बजे, टावर लोकेशन डेम दूधी कपाली है। जो बोल रहे हैं कि डेम दूधी के कपाली, वहाँ मेरा घर भी है।
लेकिन उस समय आपका पहले तो सोनारी
सोनारी मेरा एड्रेस भी वही है।
इंसिडेंट कहाँ हुआ?
वहाँ कपाली फॉरेस्ट में, कपाली फॉरेस्ट में इंसिडेंट हुआ है। वहीं पर बॉडी भी रिकवर हुआ है। अब मेरा एड्रेस भी देख लीजिए,
उसके ऊपर में उसी ऊपर लिखा है दोनों शिवम का, मृतक जो शिवम कुमार है, शिवम कुमार सिंह का मोबाइल नंबर और सीडीआर नंबर, इसमें भी सेम आ रहा है वर्कर। हाँ, तो लोकेशन शिवम कुमार सिंह का मोबाइल नंबर का दिनांक और समय 20:11 तक, टावर लोकेशन सोनारी और उसके बाद से डेमदुबी कपाली है। तो दोनों का जो लोकेशन और सारा चीज मैच कर रहा है। हाँ, मृतक के मोबाइल में अंतिम कॉल 21:54 पूर्व 209 सेकंड बात किया गया है मृतक के साथ।
मेरा नहीं, राहुल कुमार का
आपका लास्ट दिया है
मेरा।
हाँ, लास्ट आपका भी दिया है मेरा। कुल समय उसी समय का जो पूरा डिटेल है।
एक सेकंड, मृतक के साथ लास्ट कॉल है 21:54।
हाँ, राहुल कुमार,
ठीक है। और इनका लोकेशन कपाली में जो है इनका 21:54 में इनका क्या लोकेशन है?
21:54 कुछ कितना बात हुआ था, मेंदू कपाली है
मेरा घर का
डेमदुबी कपाली, उस पर बोल रहे हो डेमदुबी कपाली। इसका भी कपाली आ रहा है डेमदुबी, और यहाँ जो हम लोग पढ़े इसमें भी डेमदुबी कपाली है। 1954 में इसका आ रहा है और 2154 में
मेरा घर डेमदुबी कपाली है, इसलिए लोकेशन मेरा घर कहीं आ रहा है। और एज पर कन्फेशन मेरे घर पर वो मर्डर करके आया, हमने उसको असिस्ट किया, यही है। वो मेरा भी कन्फेशन है।
पेज 52 के लास्ट में आ रहा है। सीडीआर लोकम पाया कि कान के मृतक शिवम कुमार सिंह, कान के प्राथमिक अभियुक्त राहुल दास और मोहम्मद आसिफ को हाशिम का तीनों का टावर लोकेशन घटना के दिन एवं समय घटना के
कपाली
में पूरा आइडेंटिफाई के तीनों एक साथ।
कपाली में हम तो बोल ही रहे हैं, जो मेरे घर में नहीं दैट इज
बात कर रहे हैं,
रिकॉर्ड पर ही बोल रहे हैं।
हम उनसे भी बोल रहे हैं जो ऑन रिकॉर्ड में है उसकी बात कर रहे हैं।
चार्जशीट हो गया?
हाँ, चार्जशीट हो गया।
कब से हैं आप?
कस्टडी है फ्रॉम 7/3/2025।
चार्जशीट कब हुआ?
डेट एग्जैक्ट
चार्जशीट हो गया? एविडेंस चल रहा है? एविडेंस चल रहा है?
5/25
एविडेंस का स्टेटस चेक करने से
एविडेंस चल रहा है कि नहीं चल रहा?
एक चीज और मेरा भी कन्फेशन है, उसमें भी यही चीज है।
किसका कोई एक्यूज का बेल हुआ है?
नहीं, कोई एक्यूज का बेल नहीं। हु इज देन टू को एक्यूज, मैं को एक्यूज है राहुल दास, जिनसे डिस्प्यूट है। उन्होंने कहा कि हम मर्डर करके हम इनके घर गए।
इतना एंशियस मत होइए, हम आपको बेल दे रहे हैं।
Sorry.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that there was that as per the allegation, as per the confession statement of co-accused, namely Rahul Das, he has given reasons for inimical terms with the accused, with the deceased, and he has taken the name of the petitioner only to whom to whom he approached after commission of the offence. And the allegation against the petitioner is that the petitioner had assisted him in connection with destruction of some evidence.
Providing clothes, जो खून लगा clothes उठाती है उनको हम अपना पकड़ा देते हैं.
By providing him clothes. He submits that there is neither any recovery nor any material against the petitioner. He has further submitted that as per the CDI report, the mobile location of the petitioner was in Dambubi, Kapali, and the residential address of the petitioner is also Dambubi, Kapali. And therefore, it was very natural that his mobile location was found in Dambubi, Kapali. The learned counsel for the state has opposed the prayer, and he has submitted that the mobile location reveals involvement of the petitioner. However, there is no recovery from the petitioner, and the name of the petitioner has transpired in the confession statement of the police.
They have named in the FIR.
Named in the FIR also, prior to the occurrence, he has threatened to face the act.
Rahul Das के साथ
दोनों के साथ नहीं.
He has submitted that the petitioner is named in the FIR, and the petitioner and the co-accused had Rahul Das had threatened
2 days prior to the
2 days prior to the occurrence to kill the victim. After hearing the learned counsel for the parties and considering the fact that the name of the petitioner, considering the fact that the co-accused, namely Rahul Das, had confessed his guilt and has stated that the deceased used to improperly behave with his girlfriend.
No, his brother, deceased brother, उसके भाई
के बारे में पढ़िए ना शिवम कुमार सिंह
उसके भाई के द्वारा, बड़े भाई के द्वारा, किससे पढ़िए, बड़े भाई के द्वारा, बड़े भाई के
मेरी एक गर्लफ्रेंड है जिसका नाम पूनम है जो सोनारी में रहती है, उसको भी शिवम कुमार सिंह शिवम कुमार सिंह ही है ना डिसीज
शिवम कुमार सिंह
used to inappropriately behave with the girlfriend of Shivam Kumar Singh, the deceased. The description of the incident as disclosed by the co-accused does not involve the petitioner in any offence so far as the commission of murder is concerned.
इसमें इसका जो है असीम कुमार का स्टेटमेंट इसमें शुभम कुमार सिंह हो रहा है. हाँ देखिए ना पढ़ने दीजिए.
शिवम कुमार सिंह.
हाँ शुभम. पेज 19 आ रहा है.
19 में कहाँ पढ़ रहे हैं?
19 में
14 नंबर.
हम 19 का पढ़ रहे हैं जो असीम जो प्रोजेक्ट पिटिशनर है उसका कन्फेशन का निकल जाएगा. वही नहीं वही चीज नहीं आया. देख लीजिए. तो सोनारी थाना के बिंदर ब्लॉक के पास चाय बेचने का काम करता था. वहाँ पास में शिवम कुमार सिंह और शुभम कुमार सिंह का भी चाय का दुकान है. राहुल दास का शिवम कुमार सिंह से कुछ दिनों से बहुत विवाद चल रहा था, जिसमें आज 3-4 दिन पहले.
आप सिर्फ इतना सा बताइए, इनके कन्फेशन स्टेटमेंट में कहीं है कि he also participated in committing murder?
नो
नहीं है ना? The
But the allegation in जो
allegation तो रहेगा ही ना, तभी ना trial face कर रहे हैं. The learned counsel for the state has not been able to point out any material either in the confession statement of the co-accused or in the confession statement of the petitioner also that the petitioner had any role in commission of murder of the deceased. And the fact remains that the charge sheet has been submitted, the petitioner is facing the trial. After considering the aforesaid facts and circumstances, and it appears that even in the confession statement of the co-accused and also the petitioner, the role of the petitioner the role of the petitioner has not been mentioned in the commission of murder of the deceased. And so far as CDR location is concerned, the petitioner's tower location has been found in Dandubi Kapali, which is in which area the petitioner has the residence. Considering the aforesaid fact, the petitioner is directed to be in Jharkhand.
Mathematics BA 10718 of 2025. Item 19 BA 10727 of 2025.
May I please, Your Honor? Matter relates to the case at Maras. According to the allegation, the police got an information that some persons are not assembled at a place for the purpose of selling and purchase of brown sugar. On that matter, police come in action matters, and thereafter it is said that 3 persons were apprehended. Out of 3 matters, 2 have been granted bail. And matter said, now I am coming to the allegation. Matters, it is said that matters in the page 16, in the last third line, इसके बाद अंचलाधिकारी पेज 16 matters. हुड्डा के समक्ष राकेश कुमार, सोमू कुमार, ओम कुमार का तलाशी लिया गया. राकेश कुमार की मेडिसिनल पेपर मार्कशीट, जिसके जींस पैंट के दाहिने सिल्वर पेपर में 4 पुड़िया जैसा बनाया हुआ बरामद हुआ, जिसे खोलने पर अंदर मटमैला रंग का पाउडर बरामद हुआ. जींस के बाएं पॉकेट से पारदर्शी प्लास्टिक में किया हुआ मटमैला रंग का ब्राउन शुगर जैसा नमी युक्त चिपचिपा पदार्थों और मोटो जी मोबाइल सिम सटन बरामद हुआ. देन सोनू कुमार के बाएं पॉकेट से 4 पुड़िया जैसा बरामद हुआ, जिसे खोलने पर अंदर मटमैला रंग का पाउडर बरामद हुआ तथा दाहिने पॉकेट से मोबाइल नंबर सचिन से बरामद हुआ. देन ओम कुमार के पॉकेट से 4 पुड़िया जैसा बरामद हुआ, जिसे खोलने पर अंदर मटमैला रंग का पाउडर बरामद हुआ एंड एक मोबाइल बरामद हुआ. एंड टोटल उसको जोड़ने पर कहते हैं कि वो 12 पुड़िया 3 ग्राम है और एक मटमैला रंग के ब्राउन शुगर का प्लास्टिक जो है वो 5 ग्राम है. In totality, it is 8 grams. That is the intermediary quantity. 2 co-accused persons have been granted bail. Matters. One thing is against me. That is matter. This person is having 1 criminal offense.
Of the same offense. Of the same offense.
Of the same offense.
तब कैसे आपको bail?
This is the fact. This is my submission. I cannot suppress the real facts. But the 2 persons, on merit of this case matters, rest 2 co-accused persons have been granted.
On what ground? That they have no criminal offense?
Yes. Not
not that was ground, it was the submission that they are having no criminal antecedent.
इनका एक अपराधी
आप है मैडम?
Yes, Your Excellency.
What
It will come within the purview of intermediary quantity, more than small quantity, and he is having criminal antecedent of similar nature.
BA number 10.7.2.7 of 25, heard the learned counsels appealing on behalf of the parties. The learned counsel for the petitioner has submitted that from 3 persons were apprehended on the allegation that they are involved in sale purchase of brown sugar, and altogether 8 grams of brown sugar were recovered from their possession, which falls under intermediary.
Lady said 16 gram, 3 gram, and the other joint possession.
3 and 5, 8 grams.
8 grams.
ये क्लियर किया हुआ है रनिंग पेज 17 लिखा है.
In the impute order also it is mentioned 8 grams only.
3 लोगों के पास से पकड़ाया है लॉर्डशिप.
और जो को-एक्यूज का बेल है उसमें भी लिखा हुआ है 8 grams.
3 ग्राम, 5 ग्राम.
बस 8 grams.
8 grams ही है.
कुल वजन 8 ग्राम.
Okay.
8 grams of brown sugar was recovered, which falls under the intermediary category. He submits that 2 co-accused have been granted bail by coordinate bench of this court, and the third one who was apprehended is the present petitioner. The learned counsel for the state has opposed the prayer and has submitted that the and I submitted that the petitioner has one criminal antecedent of similar nature. After hearing the learned counsel for the parties and the fact that the petitioner was apprehended on the spot while being involved in sale and purchase of brown sugar, and there is recovery of 8 grams which falls under intermediary quantity from the petitioner and other 2 co-accused, and also that the petitioner has one criminal antecedent. This court is not inclined to enlarge the petition on bail. Accordingly, his bail application is dismissed. At this stage.
Item 20, BA 10735 of 1025.
This case I clear for some time to file a supplementary.
आपका इतना सारा antecedent
हाँ उसी का फाइल करना है. In some cases I have been acquitted that I will bring on record. That's why I will file a supplementary.
कब तक फाइल करेंगे?
After 1 week.
NDPS भी है सर.
हाँ NDPS after 1 week. In some cases I acquitted, in some cases I have not been sent remanded in this case up to now. That I will bring on record.
Counsel for the petitioner seeks adjournment by stating that although there are numerous criminal antecedents of the petitioner, but he has been acquitted in most of the cases. And also?
He has been also acquitted for a number of the cases that I
He has been acquitted in most of the cases. Post next week?
एक वीक के बाद जो है उसको डॉक्यूमेंट्स वगैरह निकालना पड़ेगा.
उसका रिवोटिंग कर दीजिए।
पोस्ट ऑन 9 March.
Item 21 PA 10746 of 2025.
Grant of regular bill for the offence under section 396 corresponding to 366 JIPC and 3 of 5 of the BNS. The prosecution case is sought that the
It is the allegation is abating to suicide.
no, but the procreation of minor 396 BNS corresponding to 366.
366.
Diary was called
And the section is what is BNS? BNS is the section 96.
96. And diary was called for earlier by law, and during investigation, the statement of the victim was recorded under section 180 of the BNS. These were 50 of the police statement, in which she had stated that was Shivam Kumar, who is younger brother of Krishna. हम बातचीत करते थे 2 सप्ताह से, घर वालों को शक हुआ, हमको मारपीट करते थे, हम गुस्से से घर से निकल गए, कहलगांव गए, दिल्ली गए। दिल्ली में शिवम जो मेन एक्यूज है, जो लेबर का काम करता था दिल्ली में, उसको कॉल किए, दिल्ली आया स्टेशन और हम उनके साथ गए। वो लेबर का काम करता था, हम भी लेबर का काम करने लगे औरत के साथ। In which my name has not taken by the victim. It's for 50 of them. We are permitted to place the statement of the
FIR पढ़ी.
उपरोक्त लिखित विषय में संबंध में निवेदन पूर्वक कहना है कि मैं दूसरा खातून उम्र 35 वर्ष पति मोहम्मद इफ्तिखार ग्राम बेलिया थाना मसंदा जिला गोड्डा का स्थायी वासी दिनांक 29/8/2025 को मेरी नाबालिग पुत्री तरन्नुम खातून
नाम नहीं लेने का है ना.
उम्र सच के करीब 3 बजे घर से निकले, जो अभी तक वापस नहीं आया। अपने स्तर से काफी खोजबीन करने पर पता चला कि गांव के शिवम पासवान, जो यंगर ब्रदर दिनेश पासवान फादर, अर्जनासु देवी मदर, हेमंता पासवान ब्रदर सन ऑफ द छोटू पासवान पिटिशनर, पिता दिनेश पासवान सभी ग्राम बेंडिया थाना बसंतरा के द्वारा शादी के नियत से बाला पुस्ताकर लेकर भाग गया, जो कि अभी तक वापस नहीं आया है। इस संबंध में आज दिनांक 5/9/2025 को थाना में आवेदन दे
विक्टिम रिकवर हो गई है.
विक्टिम रिकवर हो
उनका
गया।
क्या स्टेटमेंट?
स्टेटमेंट जो पढ़ते हैं पैराग्राफ 50 ऑफ द पुलिस। अपनी तरन्नुम खातून
जस्ट पैरा 50. विक्टिम का नाम नहीं लेंगे प्लीज.
सच उम्र सच 15 वर्ष।
रिकवर कहाँ से हुई है?
जब इसको पता चला कि शिवम पर और उनके परिवार पर FIR हो गया है, तब यहाँ आई।
ठीक.
अपार्ट फ्रॉम
चलिए बात पढ़ी.
15 वर्ष सचनसा जिला गोड्डा का जान लिया। ये अपने बयान में बताई कि
ये पैरा 51 में तो
50
किया
पैरा 50 में तो अनुरोध किया.
नहीं 50 में
पैरा 50 तो देखिए तो नहीं, कुछ मिसमैच है इसलिए दिखाई दे रहा है. कहीं दूसरे केस का तो केस डायरी नहीं बन गया.
ये दूसरा हमने पास जो आया है केस डायरी उसमें
दिखाई सर. ये केस डायरी आपका केस डायरी से मैचिंग क्यों नहीं? इसमें कुछ भी निकालिए कहाँ पर. आपको जो दिए हैं उसमें कुछ भी निकालिए कहाँ. आपने काउंटर एफिडेविट में भी डाला है इसको. है उसमें दिखाइए, देखिए.
हाँ
पढ़िए सर। हाँ पढ़िए। नाम मत पढ़िएगा।
आपने बयान में बताई कि मैं अपने गांव के शिवम पासवान से बातचीत करती थी या घर वालों को शंका हुआ तो मेरे माता पिता मेरे साथ मारपीट करते थे, जिसके कारण गुस्से में आकर दिनांक 29/8/25 को बिना किसी को बताए मैं अकेली घर से भागकर खालवा चली गई और वहाँ से ट्रेन पकड़कर दिल्ली चली गई। दिल्ली में रेलवे स्टेशन से फोन करके शिवम पासवान को स्टेशन बुलाई और उसको
क्या करें बताइए, बेल दे दें?
माइनर कर 14 साल
तो कहाँ बोल रही है कि शिवम लेके गए? ऐसा भी तो नहीं बोल रही है।
ऐसा नहीं।
शिवम के पास से रिकवरी भी नहीं। ये पकड़ाई कहाँ से? ये तो खुद ही आ गई ना।
शिवम है भी नहीं।
हाँ?
हम शिवम है भी।
अब कौन है?
हम
छोटू
पासवान।
ये तो शिवम भी नहीं है।
नहीं।
BA number 1074/6 of 2025. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner has submitted that the allegation as per the FIR is that the minor daughter of the informant filed by the father of the victim, who is minor, who had left her house without informing anyone, and the case has been lodged by stating that she was having some affair with Shivam Paswan. And the case has been lodged against all the family members of the petitioner. Petitioner Chotu Paswan is not though named in the FIR, is the brother of Shivam Paswan. Elder brother of Shivam Paswan. He has submitted that the statement of the victim, who herself returned, has been recorded, and she has not supported the case of the prosecution. Rather, she has stated that she left home on her own accord on account of her ill treatment at home on the ground of some relationship with Shivam Paswan. The learned counsel submits that the petitioner has no role to play, and considering the statement of the victim, the petitioner may be enlarged on bail. Counsel for the state has opposed the prayer. However, could not point out any material from the case diary so far as the role of the petitioner is concerned. Considering the investigation over, to this, the counsel for the petition has submitted that the charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the statement of the victim of the minor girl as found in the case diary, the petition is addicted to be enlarged on bail.
Item 22, DA 10781 of 2025.
Yes, petitioner.
Only the bill application was rejected.
By whom?
These three ladies.
By whom?
You only point. for your lordship's kind consideration would be, please just have a look to the order passed by the learned additional sessions judge in case of petitioner number 1, that is at page number 17.
Yes.
This third paragraph, page number 17, heard both the parties and peruse the record. From perusal of the record, it appears that the witnesses examined under section 161 CRPC have supported the case of the prosecution, which is apparent from para 9, 12 to 16 of the case diary. It further appears that petitioner in her confessional statement, along with other co-accused Savitri Devi and Anya Devi, in para 24, 22 and 20 of the case diary, specifically admitted about their involvement in the present case. But from the post-mortem report mentioned in para 5 and 60 of the case diary, it is apparent that the death of the informant was due to drowning, and there is a seizure of blood-stained towel from the place of occurrence. It was a case of drowning, and these three ladies, before your lordship, are all related to each other, and only on the assumption of that dying which they are in custody, and they have been. They are in custody since 28/5/2024.
28/5/2024. What is the stage of the trial?
The stage of the trial is charges have been framed, and some of the witnesses also have been.
All the lड़की 28 से 11 25 को कॉल पर स्टेज
क्या चीज?
कॉल पर स्टेज
Stage. What is the stage? आया होगा ना report?
Charge sheet charges have been framed, and some of the witnesses have been examined.
4 witnesses out of 8 have been examined. Heard the learned counsel appearing on behalf of the petitioners. It is submitted that the bail application of the petitioners, only one petitioner?
No, 3.
तीनों का reject हुआ?
That we have to
The bail application of each of the petitioners have been rejected by coordinate bench earlier. He submits that from the impugned order itself, it is apparent that the cause of death was drowning, and by rejecting the bail application earlier, it was mentioned that the accused person had collectively strangulated the deceased. यही बोलना चाह रहे हैं ना?
It was a case of drowning.
That's right. The learned counsel for the state has opposed the prayer and has submitted that there is a seizure of blood-stained towel from the place of occurrence. And the trial is in advanced stage inasmuch as the status of trial as received from the court concerned reveal that 4 witnesses out of 8 charge sheeted witnesses have already been examined. After hearing the learned counsel for the petitioners and considering the fact that the bail application of the petitioners have been rejected on merits on earlier occasion, and that the nature of allegation is quite serious, and the trial is in advanced stage, this court is not inclined to release the petitioner on bail accordingly.
Item 23, DA.17.02.2026 of 2025.
Yes, petitioner.
the case of chain snatching, allegation against this petitioner is that he is the goldsmith and he has purchased the gold relative from the other accused persons. He was not named in the affair. Affair was as against one owner of the motorcycle that he has snatched the chain. Subsequently, it has come that that owner has been apprehended.
The chain has been recovered.
No, the stolen chain has not been recovered.
But he said that he has sold it to you.
That was the confession that he has said that he has sold it. It was the confession. The stolen article has not been recovered. Since I was the goldsmith.
So ना आपके पास stolen का आर्टिकल कहाँ से मिलेगा?
ये केस भी है जो उनका है कि भाई वो आया और इसको वो गला दिए, गलाने के बाद ये आया. But that was not the recovery.
Any antecedents?
Yes, he has antecedents. He has 3 antecedents. Next stage of trial is because stage of trial.
कोई जरूरत ही नहीं है stage of trial.
In the
4
same-
antecedent है ही.
4 antecedent पुराना.
अब इनको बोल दे आपका चार्जशीट हो चुका है.
चार्जशीट हो चुका 2019 का एक केस है, 2020 का.
कोई बात नहीं, कभी कभी हो, आदमी तो वही है.
But अभी इधर goldsmith है. इनका परचेज है मैक्सिमम 411 412 का केस होगा. चोरी का सामान खरीदने का मैक्सिमम एलिगेशन होगा. डकैती या कोई भी रॉबरी करने का एलिगेशन नहीं है. उसका पनिशमेंट डिफरेंट उस पे.
कितना है आपका पनिशमेंट मैक्सिमम?
मैक्सिमम बहुत ये रॉबरी का प्ले नहीं है बट 412 411 का पनिशमेंट 3 साल. एंड ही रिमेन इन कस्टडी फॉर मोर देन 13/9/2025. एक बार स्टेज ऑफ ट्रायल वर्ष में कॉल. स्टेज ऑफ ट्रायल से एक्सपेडाइट हो जाएगा.
आपका ट्रायल एक्सपेडाइट ऐसे ही करा देते.
स्टेज ऑफ ट्रायल में एक स्टेज ऑफ ट्रायल मंगाने के बाद एक्सपेडाइट होता है. एक बार स्टेज ऑफ ट्रायल मंगा के
At the request of the counsel for the petitioner, office is directed to call for the stage of trial of the case from the concerned court. Post on 10th of March.
12 के बाद इलेक्शन है.
12 के बाद. Post on 16th of March.
Item 24, DA 10847 of 2025.
Yes, please.
This is a file has been registered under section 506, 420, 504 and 506 of IPC. Which the allegation against the petitioner in this case is that he, along with 2 other persons, represented the informant that they were running a company dealing with sale and purchasing of land. And consequent thereto matters, the informant and the petitioner entered into an agreement to sale, which was subsequently not executed on behalf of the petitioners for the reason that one of the directors who was the main partner in all this transaction has died and was substituted by his wife, and therefore this case has been lost. The petitioner is already in custody since 19/10/2024. Already matters in the first instance matters the petitioner was enlarged on bail on 16.
कितना पैसा लिए थे एग्रीमेंट?
17 लाख.
क्या किए 17 लाख?
17 लाख का था, उसमें 17 लाख का मेरे अगेंस्ट एक भी जो भी पैसा अमाउंट है वो मेरे अकाउंट पे ट्रांसफर नहीं हुआ. जिन पे हुआ है दे आर एन्जॉयिंग द प्रिविलेज ऑफ एंटिसिपेटरी बेल सिंस 2020. चार्जशीट हैज ऑलरेडी बीन फाइल्ड इन 2022. 4 विटनेस आउट ऑफ 6 हैज बीन एग्जामिन्ड.
आप 2 आदमी गए थे ना, दूसरा कौन?
3 टोटल 3 हम थे और 2 मेरे साथ पार्टनर्स थे. एक डेथ कर गया, उनकी वाइफ है, और जो तीसरे हैं वो भी एंटिसिपेटरी बेल विलेज ऑफ एंटिसिपेटरी बेल. मैटर्स मेरे अगेंस्ट ट्रांजैक्शन एक भी पैसे का ट्रांजैक्शन नहीं है. फ्रॉम पेज ऑफ पैरा 32 ऑफ द केस डायरी इट वुड बी क्लियर मैटर्स दैट एक भी अमाउंट जो है वो डायरेक्टली
आपका एंटीसीडेंट भी?
नो मैटर्स.
From the perusal of the entire case diary, it appears that the accused has committed misuse of privilege of bail.
What has happened in this case matters. First of all, on 16/12/2022, the petitioner was enlarged on bail with the condition that the
on
16/12/2022.
ये कहानी कौन बताए? You were not coming to this.
So
who enlarged you on bail? So where is that order? पहले तो previous order ही आपको place करना चाहिए. किस तरह का ये आप लोग argument करने का? Previous order you will suppress. That is the opening sentence. You were not coming to that. Please don't tell me that you were coming to that.
I have annexed the order by which I was granted bail and the subsequent order by which my bail was cancelled, rejected. At annexure 1, page number 16.
Applicant had executed the bail, the agreement. You were the party to the agreement of sale. You had executed the agreement. Then how do you say एक पैसा हमको नहीं मिला?
केस डायरी में क्लियर है कि
केस डायरी का कहानी बंद करिए.
all the amount has been transferred in the account of the company.
उससे क्या लेना देना है? आपने आप एग्रीमेंट करिए और बोलिए किसी के नाम से ट्रांसफर कर देने से क्या लेना देना? You can get the consideration amount transferred to any person you want.
I was not even the.
Then what happened? After this, what happened? What you misused the privilege of bail?
I was given the bail on the condition that we will execute the agreement to sale with the assistance of other partners of the company. However, the other partners declined, refused to execute the sale, and thereafter my bail was cancelled. I have also annexed, my lords, the anticipatory bail at page number 26, my lords, wherein specifically the mediation report has been referred to by the Honorable Court while allowing the anticipatory bail.
ये तो आपका anticipatory bail तो दूसरे का है ना?
It has been specifically stated in that order by which they have been allowed the anticipatory bail that it appears from the impugn order itself that during the pendency of the anticipatory bail application of the present petition, the matter was referred to the mediation center, wherein co-accused Ashok Ram has undertaken to execute the sale deed in land of the said land in favor of the informant, and present petitioners have undertaken to assist in the execution of the sale deed. And since these co-accused minutes, they were the director of the company.
You don't bother about it.
So without their assistance, it was very difficult for me to execute the sale on behalf of the company.
We can't do anything about it. It is for the informant and others to go for specific performance of contract. We are not there.
And my lords, I am already ready for almost 2 years in total. The trial has commenced, my lords. Only 4 witnesses have been examined till now out of 6. Charge sheet has been
out of 6 4 हो चुका है ना? बहुत एडवांस स्टेज में है ट्रायल.
2022 में हमारा चार्ज शीट फाइल हुआ है. अभी तक 4 इसमें
हो जाएगा सर. स्टेट है आप?
No, I am the informant in this case.
स्टेट है ना? दो तो खाली आईओ बचा होगा, क्या ही बचा होगा?
IO has also been examined, my lords.
तो ये दो कौन है witness?
They are the independent witness during the arrest of the.
अच्छा. तो कोई दिक्कत नहीं है आपको.
But if I may be allowed to place, I would like to place my reliance upon section 437 of CRPC 6 specific rule, which specifically provides that in case the date has been fixed for evidence from that particular date till the conclusion of 60 days, the trial should be concluded. Although this is a discretionary power provided to the
BA number 10847 of 2025. Or the learned counsel appealing on behalf of the petitioner. He submits that the petitioner was granted bail by the order dated 16 December 2022 in BA number 8143 of 2024 on some condition, and particularly the fact that the petitioner agreed to execute the sale deed arising out of the agreement of sale in favor of the informant, wherein it has also recorded that the petitioner also admitted receipt of rupees 17,20,000. He submits that on account of intervening circumstances, the sale deed could not be could not be executed, as one of the directors had expired. He is also directors of the other persons had expired, one of the directors of the company involved in this case had expired. The learned counsel has also submitted that the persons who took part in negotiation have been enlarged on bail, on anticipatory bail by the order dated 29/8/2022. And the petitioner is in custody since 19/10/2024. He has submitted that out of 6 witnesses, 4 witnesses have already been examined. Counsel for the informant has opposed the prayer for bail and has submitted that the petitioner did not comply with his own undertaking given and recorded in order of bail dated 16/12/2022 in DA number 8143 of 22, and therefore his bail has been cancelled. He has also submitted that the trial is at advanced stage. After hearing the learned counsel for the parties and considering the fact that the petitioner was granted bail on account of certain condition that on account of certain submission that he was ready to execute the sentence and has also submitted that he had received rupees 17,20,000. The agreement was entered as per the allegation. The agreement was entered into between the petitioner and the informant. आप ही दोनों पार्टी है ना एग्रीमेंट की?
तीनों पार्टी है जो और भी डायरेक्टर से they were also party to that.
नहीं, they were the introducers.
I was the introducer. I introduced the informant with the other 2 directors.
While granting the anticipatory bail to other co-accused, it has been recorded that the allegations are centered around the petitioner. And since he was already in custody, the anticipatory bail was allowed. This court finds that the trial is in advanced stage and there is direct allegation against the petitioner. In such circumstances, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the concerned authority to ensure compliance.
From supplementary list, for to be mentioned case item 1, second appeal 126 of 2003.
It has been listed at the instance of the office. The next date mentioned in order dated 11 February 2026 in essay number in this case has been shown as 10/2/26 instead of 10/3/26. Peruse the record. There is an inadvertent mistake in putting the next date. office is accordingly it is directed that the next date in paragraph 5 of order dated 11/2/2026 be read as 10/3/2026 instead of 10/2/2026. Office to carry out the necessary correction in the order. Post this case on 10/3/26. It is CAB order.
Item 2, SA 293 of 2017.
Have you made the payment?
Yes, Your Excellency, I have also filed a supplementary. Dated 12th February 2026. It should be 90 pages, page number 5.
Applicant is absent. The learned counsel for the respondent has submitted that payment in terms of the last order has been made and a supplementary affidavit has been filed to that effect. The matter was heard at length on the last date and the order was reserved. For this case, as it turned out, judgment is not. CAB तो ऑलरेडी है ही। उस समय खाली इसी के लिए हुआ ही था कि
Leadership has also made an observation that if the order will be written, it will be given.
अभी तक नहीं
As made.
From date is after termination case Act 25, second appeal 106 of 2024.
Yes, the case is otherwise ready.
Yes.
You are ready?
Let me see here.
So you want time?
Please,
Sir, pass it.
This matter is at length, heard by your lordship, and the last order of your lordship, dated 9th of December, in which your lordship was pleased to, after hearing Lord at length, had been pleased to frame Lord a substantial question of law. This order may kindly be seen, Lord.
Yes, it is there. It is and now an additional substantial question.
Your Lordship will kindly recall, Lord, that the petitioners are the daughters of the recorded tenants and defendants. We are defendants, Lord. Now, the trial court, Lord, and the plaintiff is claiming themselves to be in the genealogy of.
You see, prior to holy vacation, it may not be possible to hear this case because we are now doing so much of bail matters also. And 10:30 बजे से हम लोग का भी hearing नहीं होगा. I posted post vacation, and then interim order has to be extended. Yes. You choose your date after vacation. Immediately after vacation. He doesn't have any issues on that.
After holy.
Yes. The learned counsel for the parties are present. Let this matter be posted for panelist posting, posted under the same heading after the holy break. after the ensuing holy break. 11th March. Till 11th of March, the interim order is extended.
मेरा प्रेयर 13-14 या 15 थोड़ा होली का छुट्टी है
13, 14,
ऐसे प्रयास तो हम लोग
15
करेंगे
सैटरडे संडे है
तो आगे और थोड़ा 2-3 डेट
देखिए उनको ऑब्जेक्शन है आपके इंट्रीम ऑर्डर एक्सटेंशन पर इसीलिए ऐसे डेट नहीं है It is only because of these bail matters I am not hearing it. Otherwise I would have heard this.
We will do this.
अब सेकेंड अपील का स्टोरी भूल जाते हैं जब इतना टाइम पार हो जाता है तो there is lot of family stories.
And so many matters are coming.
So many matters. At times एक का कहानी दूसरे में मिक्स
और
होने
अभी तो
लगता
बहुत डिफरेंट स्टोरीज हुजूर के यहाँ आ रहा
है कोई बेल ऑर्डर में प्लेंटिफ लिखा जाता है
अभी बहुत तरह का जुरिस्डिक्शन हुजूर एक ही दिन में एक्सरसाइज हो रहा है
और hearing on order 41 to
कहाँ से
11
होगा आज ऑर्डर 41 किसका मैटर है कॉल करिए
item 49 second appeal 184 of 2020
only one point below on the point of limitation. Lordship may kindly see suit was filed below for declaration of title and confirmation of possession in the alternative for recovery of possession and for cancellation of sale deed executed by the defendant number 1 in favor of defendant number 2. Now, my lord, the learned trial court has decided issue number 6 below against the plaintiff, and the learned trial court came to a specific finding that so far as prayer for cancellation of sale deed is concerned, it is hopelessly barred by limitation. And thereafter we lord decreed this. Now my lord is aware of the judgment of the Honorable Apex Court, in which it has been held lordship that if suit has been filed for declaration of title and recovery of possession and for cancellation of sale deed, the provision contained in Article 59 of the Limitation Act would be applicable. This is lordship may kindly see. This is lord the judgment of the Honorable Supreme Court.
You are the defendant.
Lordship. And lordship may kindly see para 14 is relevant, lordship. And lordship may kindly see the findings of the learned trial. And lordship may kindly see the findings of the learned trial. Para 25 lordship, page 20.
Sir, I need to rise. कल सुने
Day after
या
day.
सप्लीमेंट्री लिस्ट में डाल देते हैं कोई टाइम फिक्स
कर दिया
1 o'clock
कर दिया
AC number 184 of 2020. The argument has remained inconclusive as the court time is over. At the request of the counsel for the petition appealant, pose this case day after tomorrow to be taken up at 1.